Good afternoon. Judge Manzanet is the judge presiding today. She is not with us at this moment, but she is listening very carefully to the arguments and will be fully participating in the deliberations. We have over 6 hours of argument. Obviously, you folks don't want to be here late into the evening, so we request that you ask the time you need to convince us of your arguments and not the time you think you need to educate us about your case, because we are a hot bench. People versus Galarza.
Appellate requests 4 minutes with 1 for rebuttal.
Respondent requests 3, Your Honor.
413. Kataskewa versus New York City Transit Authority.
Appellant requests 5 plus 1, Your Honor.
5, 1, and 5. S. Children, submitted. Salcedo versus Strathmore Construction.
Respondent plaintiff, 3 minutes.
Okay, so 4, 1, 2, and 3. Valone versus Wakano. 4, 1, and 4. People versus Jackson.
Appellate requests 4 and 2.
I must say, folks, you are really paying better attention. When I was going through the calendar myself, I was giving you folks a little more time, but don't change what you're doing. Carver versus Artelis. Respondent? So you have no respondent here, sir. What would you wish to do? You'll submit? Very good. IO Experience versus CNA Marketing. 5, 2, and 4. People versus Rodriguez, submitted. Ward versus New York Police Department. Very well. R.W. Children, submitted. 111 West 57th Street versus 111 West 57th Mez. The appellate, Your Honor, 8 and 2, and 1 minute on the cross appeal. Okay, and for the plaintiff? Very well. Counsel?
8 and 2 for rebuttal.
So 8 and 2. Okay, very well. 8 minutes. I'm sorry, go ahead. Okay, very well. People versus Davis, submitted. Hilton versus WTC Tower. 4, 2, and 2. People versus Bacon. 5, 2, and 4. Oversight Management versus Solomon. 5, 2, and 5. People versus Negron. 3, 2, and 3. Yacarno versus Koenig. 5, 2, and 3. People versus Alexander. Submitted. BLDG ABI Enterprises versus 711 Second Avenue is submitted, as is the final case on the calendar, Bronx Car versus Fordham Hill. Okay, first case, People versus Galarza. Oh, did I skip one? I'm sorry, which one?
Gupta.
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 I apologize, I did skip Gupta. Okay, what does plaintiff want? The appellant. 5 and 2? Got it. Sorry about that, folks.
Good afternoon, I'm Catherine Martone on behalf of Mr. Galarza. As the district attorney concedes, at the SORA hearing in this case, the prosecution failed to establish when the alleged acts occurred relative to each other. As a result, the hearing court erred in assessing Mr. Galarza 20 points under risk factor 4 for engaging in a continuing course of sexual misconduct. Mr. Galarza then should have been assessed a total of 85, not 105
That
points.
doesn't change the his level, correct? It's still a level 2, presumptive
He's
level 2.
still a level 2, although he is now more at the lower
the lower
end
end.
of
So
level
the real
2.
issue now is your application for a downward departure.
Yes, Judge. And the court erred in that regard because the mitigating circumstances here included the fact that Mr. Galarza, at the time of the SORA hearing in 2021, was 72 years old. And he
But
had,
isn't that of less importance, given that he was 68 at the time of the incident that is at the basis of this?
you know, Your
I
Honor,
mean, it's not like 20 years had passed and he's now more mature.
That's true. I think that the district attorney's argument in that regard somewhat confuses the issue because the research and the cases we're relying on relate to the strong association between age and recidivism.
But does that come into play when we're talking about somebody who did the act at age 68 and is now all of 72? Does the research support a significant difference in that age span?
I believe that it does, Your Honor, because what we're talking about here is the maturity that comes with age.
And what I'm asking you, is there any research that shows that somebody who did something like this at age 68 would mature significantly in the next 4 years?
The research that we're relying on relates to recidivism. So this is the notion that a person learns from his mistakes. Having been prosecuted and punished for the crime, an older person like Mr. Galarza, who is more mature, is less likely to repeat the same mistake. That's the notion
Even if you're
here.
correct about that, don't the aggravating factors to what happened here, don't they outweigh any mitigating factors?
I think that the strong thing that we're relying on here, Your Honor, that the risk assessment instrument does not capture is just the truly aberrational nature of the misconduct here. His criminal history in this case is so remote, it was in the 70s and 80s, because he lived a law-abiding life without any supervision for 17 years before he was charged in this case. So what we have is a person with a demonstrated ability to live a law-abiding life who has never committed a sex offense previously, who at the age now of 72 has fully acknowledged his guilt and accepted responsibility and accepted treatment. And I think based upon all of that, presents a very low risk of reoffense.
Thank you. Counsel?
Good afternoon, Your Honors. May it please the Court. Elliot Hamilton for the Office of the Bronx District Attorney. My adversary's argument is predicated on the fact that all these factors, these mitigating factors, were not taken into account in the risk assessment instrument. In fact, they were. He did have a remote criminal history, but he had a criminal history nonetheless. 17 years of unsupervised liberty did not prevent him from raping a 10-year-old girl. As a result of that, there were aggravating factors that made it very clear to the SOAR court that he did not deserve a downward departure. Notwithstanding the 20-point concession that we are making with respect to factor 4, there was no clear and convincing evidence that his involvement in treatment was exceptional, which is required by the guidelines. His satisfactory prison record was already taken into account with no points assessed under factor 13. And it's also important to note that the age argument was unpreserved, because the only time that the SOAR defense attorney mentioned age was relative to the criminal history. He was not making an argument that he was of such an age that would lower his rate of recidivism. So our contention is that my adversary's point to that is unpreserved. And if you have no further questions, we ask that you affirm the underlying judgment, render him a level 2.
And you are conceding the additional 20 points, son?
Yes, the people did not meet clear and convincing evidence with respect to factor 4. Thank you, Your Honors.
Thank you. Counsel?
I waived my rebuttal, Your Honor.
Thank you very much. Next case, Carrasquela versus New York City Transit Authority.
May it please the Court, Tim O'Shaughnessy, MTA Law Department for Transit. Everyone's in agreement Transit had no duty to remove the snow from the spot where the plaintiff fell, and that the only way that there might be an issue of fact on this motion is if someone from Transit removes snow more than 3 to 4 feet, the customary 3 to 4 feet from the entrance to the subway building, and piled that snow in a manner that made the spot where plaintiff fell more dangerous. There's absolutely no evidence of this. It's pure speculation. The photograph shows that the bare spots do not have.
The 3 to 4 foot rule essentially is a rule of reason, maybe, by the Transit Authority, correct?
In fact, what the 3 to 4 feet is the Transit actually has no obligation to the public to clean the 3 to 4 feet. That's an obligation that Transit's cleaners have to their employer. But it's irrelevant here because the spot where the plaintiff fell was clearly nowhere near 3 to 4 feet. In fact, in the documents, it's referred to as 25 feet from the subway entrance.
And did the plaintiff fall on the pathway, or actually, at least from the photograph, it appears that the fall was somewhere else? Is that correct?
That's correct. He fell on snow and ice. As the photograph on page 199 shows a little X that he made and shows that he fell on snow and ice. So not only the cleared areas have very irregular edges, which would result from pedestrians trampling down the edges of the snow rather than someone shoveling it, but also plaintiff did not testify that there was a pile of snow as if someone had shoveled, and the photograph does not show that there was a pile of snow as if someone had shoveled where he fell. In fact, in the photograph, you can see such piles way off in the distance in the background.
The area where the plaintiff fell, can that be considered a primary passageway for ingress, egress?
No, it's out in the middle of, it looks like this big plaza. It's an area of sidewalk where people could walk by the subway, and it's not exclusively used for entrance to the subway because it's so far from the door.
So it's your position that there is no duty with respect to egress, ingress for a public thoroughfare, correct?
Correct. Not on the Transit's part, and certainly not 25 feet from the door.
Thank you, sir.
Thank you.
You may begin, counsel.
Good afternoon, Your Honors, and may it please the Court, Lauren O'Brien on behalf of Respondent, the City of New York. The factual issue in this case is whether transit actually engaged in snow and ice removal efforts that created or worsened a hazard in front of the entrance of the
What's the
station.
factual predicate for that argument?
So we have these photographs in the record showing that a path was created leading up to the entrance of the subway station, and that those photographs taken together with the testimony from transit employees saying that they had certain affirmative duties and that they often engaged in snow clearing efforts.
Right, but wasn't it clear that that their position was it was like 3 to 4 feet from the subway station and not the 20 or so feet, correct?
So the testimony itself came from two separate transit employees, and it actually was inconsistent. So one employee testified that it was 4 feet, consistently said it was 4 feet, and the other employee said it was 3 feet.
Right,
and
3 to
both-
4 feet, but this is way beyond 3 to 4 feet, correct?
I think from if you look at the photograph where the X is drawn in the ice, I wouldn't say way beyond. There is a report that was written up after the incident that was not a sworn report or sort of testimony from the plaintiff that mentioned 25 feet, but it's not clear what that was addressing. If you look at the photograph, it is closer than that.
Okay, so let's assume, for argument's sake, that Transit Authority did in fact do the shoveling. How did that activity, at least based on the photographs, heighten the danger of the condition?
Well, we have the location of the fall, which is right next to the area that was, from the photographs, clearly cleared in some way by shovels or some other tools. We don't know, because transit has not provided any specific information about how that path was created or what snow removal activities were undertaken in that area in order to determine whether they were done carefully. So what we really have here is an issue of fact that remains open, and that makes summary judgment inappropriate at this stage.
So what it sounds like is what you're really arguing is that Transit didn't make out a prima facie case then.
We're arguing that the evidence in the record, that there is an issue of fact here, and that transit has not overcome that issue of fact with any evidence.
And what do you make of the argument in the papers that the X was actually on the snow and not on the pathway? So if it fell on the snow, why would transit be negligent for that?
So the theory is that the snow removal activities immediately adjacent to the spot where the plaintiff fell, that created a more hazardous icy condition in that spot. And there's case law to sort of reflect that is
But isn't there also
considered
case law? Isn't there
negligence.
case law that says if you fall on snow and not on the path, that there is no liability under those circumstances?
In the cases where summary judgment is appropriate, the defendant offers evidence that is sort of specific to the day of the incident and the location of the incident. And here, that just sort of describes exactly what snow removal activities were undertaken. And here, all we have is some general testimony from two employees about, sort of vaguely, about transit's snow removal responsibilities, and that they approximately clear away snow from 3 to 4 feet, but that's an approximation. There's no yardstick that's used to measure that area. And we don't have anything specific about who was there on the date of the incident, who cleared the path. No one even says one way or the other if transit employees cleared the path or not, or if anyone else cleared the path. So they simply haven't met their burden to establish that they were not negligent here. And unless Your Honors have any further questions, we would ask this court to affirm.
Thank you, counsel.
Just note there was no objection to those reports being admissible.
What about her position that in fact, you didn't make out a prima facie because it's just sort of general testimony about the 3 to 4 foot rule, but presumably no records as to what your activities were on the date in question with respect to snow removal?
I'm not sure that argument was made in the papers below or even in this court. And that would be an impossible burden. This snow, there's no evidence in the record, but it's clearly, it didn't fall the night before. And following that reasoning, the burden would be on us to bring in every cleaner from all 3 shifts since
Why
the
wouldn't,
snow fell to say I didn't shovel.
why wouldn't your burden just be to show that when the most recent cleaning or inspection was? Doesn't require you to bring in every cleaner.
Well, if what we must do is bring in the cleaners to prove that they did not shovel more than 3 to 4 feet.
Why wouldn't it be sufficient to bring in the person who last inspected or last cleaned it prior to the accident?
That we should be possible. In theory, that's possible, but we don't have any evidence in this record as maybe that person is retired. There's no evidence in the record about that.
Thank you, counsel.
Yeah.
The next case for argument is Salcedo versus Strathmore Construction. You may proceed, counsel.
Good afternoon, Your Honors. David Kong for the appellants, DHNY and Gemstone Property Management. May it please the court. Your Honors, cases are often decided every day, both on procedural grounds or on substantive grounds. And I'm sorry to say this case was actually before this court 2 years ago on motions for summary judgment, but it's now before this court on a procedural issue. Namely, after this court's decision on a prior appeal regarding summary judgment motions, my office was substituted in as counsel for the appellants. At that time, upon reviewing the file, we discovered that one of the named defendants, DHNY, was a non-existent entity.
Well, but that, your so-called discovery of that fact didn't depend on our decision on the motion for summary judgment or anything else.
No.
I don't understand why it wouldn't have been part of your due diligence years ago, given that
Well, I can't speak
given
for-
that the discovery is now complete and that permitting a motion to amend at this point would deprive defendants of the opportunity to, I'm sorry, plaintiffs of the opportunity to depose relevant parties and so on. It's far too late, isn't it?
Well, one of the defendants that were already deposed was an actual representative of this particular defendant, DHNY.
But at the time of that deposition, they didn't know that you were claiming that that was the owner.
Well, at that time, I think it's worth noting that even before prior defense counsel got involved in the case, plaintiff had multiple opportunities to discover that he was suing a non-existent entity. But rather than doing due diligence and correcting the pleadings,
But wait, but you made the admission of ownership, so they had no reason to go behind that. They trusted that you were making an admission that was correct.
well, prior counsel's admission to ownership, he actually handwrote in the answer that the proper name of the entity that should have been sued. But despite that, plaintiff's counsel didn't make the correction and didn't move to amend his pleadings at that time. It was only until my office made a motion to amend the answer to correct the pleadings that plaintiff's counsel finally woke up after 7 years and said, hey, I have to cross-move to amend my pleadings
But
because...
I'm sorry, counsel. I think the opposite argument is much stronger. You move after the statute of limitations expires, correct?
Correct.
And is there prejudice as a result of making this motion after the statute of limitation expires?
Well, I would argue that any prejudice to the plaintiff was caused by plaintiff's own failure to do due diligence.
Well, but again, why not just by your own failure to do due diligence to dispute the name of the entity that was sued?
Well, I can't speak for prior defense counsel, but to the extent that the lower court was correct in denying our motion to amend the answer, then the lower court should have likewise denied plaintiff's cross motion to amend his complaint then.
But is there any issue that the correct entity was not on notice of this claim?
Well, that I can't say, Your Honor.
Of course you're on notice. I mean, it was essentially it's a Scribner's error here, right? I mean, isn't that what really occurred? And you're trying to take advantage of that?
Well, to that point, like I said, if this court is going to affirm the denial of our motion to amend the answer, then plaintiff's motion, cross motion to amend should likewise be denied because, in effect, the appellants are being penalized for finally, taking action to correct the pleadings the way it should be.
What's the prejudice?
Okay, thank you, sir.
Good afternoon, and may it please the court. I'm Denise Rubin, appearing for the plaintiff respondent Luis Salcedo.
So how would you be prejudiced if we were to grant the motion to amend?
I'm sorry, say again?
Would your client be prejudiced if we were to permit the motion to amend?
Absolutely. He would be unsuited as to the owner of the building. His statute of limitations has run, his note of issue has been filed, and at that point, he has no recourse if he is not allowed to keep them in the case. And I note that counsel mentioned that it was equally prejudicial to grant the cross motion by plaintiff to correct the misnomer in the name of that entity, and I strongly disagree. The difference here is it didn't bring somebody into a case that wasn't in a case. They've been in the case since the day they answered in I believe it was 2018, if I'm not mistaken, or 2016. But in any case, many, many years. They've already been to the appellate division on a summary judgment motion and never then in their entire respondent brief ever mentioned, oh, by the way, we're the wrong guys. And their own witness for, I believe it was Gemstone's employee, but he said he was the managing agent for Gemstone and DHMY, said when asked, do you know who DHMY 4 LLC is? He said, yeah, I think that's the owner of the building. Their own witness identified that entity as the owner of the building. The cross motion being granted only allowed subsequent to trial a judgment to be collected against that entity, because if that wasn't corrected, they would have a judgment that would be absolutely pointless. They wouldn't be able to collect on it. So the level of prejudice is completely different. And unless the court has any other question, we will rest on that in our papers.
Thank you, counsel.
Thank you.
I'll be very brief. May it please the court, David Metzger for Sustainable Energy. This deals with the issue of the cross-claim. There's also the appeal seeks to amend the answer to assert cross-claims against our client. All throughout the litigation, including summary judgment and including the appeal, all the defendants were represented by the same attorney, neither of our offices, by the way. The court below looked at this argument and there was a lot of argument to be made below, denied it, determined that there was a potential for prejudice, which I can discuss, but the case law is very clear, including the cases cited by the appellant, that it's completely or almost entirely to the court's discretion with the widest possible latitude. So the court below determined that there should not be an amendment to now allow cross-claims against my client. Same issue. Did not do depositions of the two key witnesses, actually, who would be involved, and it deals with contractual issues. And the cases that we cited actually deal with the issue of cross-claims. Most of the cases cited by the appellant, where there was an amendment allowed, dealt with issues of simply adding an affirmative defense. Thank you.
Thank you.
Your Honors, briefly to plaintiff's point regarding the prejudice to plaintiff, there would clearly be prejudice to the defendant also, because had we not made this motion to amend the answer, plaintiff wouldn't have cross-moved to amend the complaint.
But it was your client who made the first mistake by admitting something which you now claim isn't true. So why wouldn't you be the one who should bear the burden of that mistake?
No, so let's say we did absolutely nothing. Once we inherited the file, let's say just, we leave this, status quo.
But the question isn't who inherited the file. We don't look at which lawyer did what. We view it as your client. You don't get to do a do-over when you come in on a case.
Well, in the prior answer, they admitted ownership, but handwrote in the answer the proper name of the entity. So to the extent that the court is going to accept the handwritten answer, or edit to the answer, then yes, the property entity is there. But again, if we didn't make this motion and plaintiff didn't cross-move, and let's say this case goes to trial and plaintiff prevails, he'd be in a position where he'd have to try to seek a judgment against a non-existent entity. So there is clearly, prejudice to the defendant by the lower court granting the cross motion, while at the same
It's
time,
not legal prejudice.
I don't understand what
It's not legal prejudice, counsel. That's just, I mean, if there's a judgment, your client may be responsible. That's not prejudice. Thank you very much. Vallone versus Volcano. You ready?
Good afternoon. May it please the court. My name is Samantha Quinn. I represent the defendants, Dr. Ettore Volcano and St. Luke's Roosevelt Hospital. There is a dispositive issue in this case which has been considered many times by this court and, in fact, many times by members of this panel. Can an expert witness opine outside her specialty without laying the appropriate foundation to ensure the reliability of that opinion? The answer is no, she cannot. Here, the surgery at issue was highly...
Counsel, in this case, the expert, although an osteopath rather than a medical doctor, is in fact the chair of a department of a respectable medical school focused on this kind of surgery. I have difficulty understanding what your argument is that the doctor's skills don't qualify him to testify about this.
Your Honor, respectfully, he was not an osteopath, he was a podiatrist. And the surgery at issue is something called a percutaneous wire calcaneal osteotomy, which is a highly specialized robotic surgery, minimally invasive, which very few surgeons do. As a podiatrist...
I'm sorry, I misspoke, podiatrist.
But as a podiatrist, in order for this doctor, Dr. Del Monte, to have testified or have opined against my client, who's an orthopedic surgeon, he would have to lay the appropriate foundation that he was familiar and had appropriate training and personal knowledge. He did not. He's never performed this surgery. And in fact, there was a highly analogous case which plaintiff's counsel relied upon in the lower court.
Okay, I'm sorry to interrupt you, but is the issue of the performance of the surgery really the issue with respect to the malpractice?
Yes, it is. Absolutely. This doctor is claiming that the surgery was inappropriately performed, and that as a result, the Achilles tendon was injured during the surgery. Dr. Mangone, an orthopedic surgeon...
The issue is not what caused the tear?
Yes, that
in
is.
this case?
So
it's really not the technique, but it's your position, as I understand it, is stress 2 months later, put on the foot, on vacation, et cetera, was the cause of the tear, not the surgical operation.
I disagree, Your Honor. What Dr. Del Monte testified to was that Dr. Volcano injured the Achilles tendon during the procedure, and our expert, who is an orthopedic surgeon who actually does this, specifically says that to have caused the injury would have taken an unusually drastic and deliberate amount of force and is highly unlikely since the Achilles tendon is not in the operative field where he was operating. Now, if Dr. Del Monte actually did this type of minimally invasive surgery, he would know that, but he doesn't. He's never done it. He didn't claim to have done it, and he doesn't have the requisite expertise to opine in this area. And just to point out, I see that my time is running out, but this very panel has opined on this issue multiple times. Justice Gesmer, in the Greenspan case, in the Lomax case, in the Steinberg case, Justice Manzanet in the Vargas case, the Villani case, the Bartolacci-Meyer-Sassone case, the Atkins case, Justice Singh, the Vargas case, the Villani case, the Perez case. It is very settled authority that this expert should not be permitted to opine outside his specialty, lacking the foundation, which he did not have.
Thank you, counsel. What about that?
Happy to jump right into it, Your Honor. They seem to concede everything else, and also by saying that, fabricate something that's not in the record. The statement that he never has performed this technique is not in the record. That's just something that's in the brief and said on oral argument.
Well, but isn't it your obligation to say that he has performed this kind of operation?
It is, and we did, because Dr. Del Monte said in his opinion, in his affirmation, my extensive
Can you give me the
experience.
citation to this?
I'm sorry?
The citation to what you're going to read from?
That's the one thing I didn't write down, where in the record from his opinion in the summary judgment motions. My extensive experience includes managing, overseeing, and participating in all aspects of the type of care and treatment as that which was rendered to Vallone. The procedure itself is a incision, removal of bone on the outside of the heel, the foot, and tendon repair. What Dr. Del Monte, the subsequent treating surgeon, he's not someone off the street, a podiatrist that might put an insert in a shoe. He is a surgeon. He is the head of NYU's podiatric surgery, which is a sub-department of orthopedic surgery. He is a surgeon that does exactly this. The surgery he did.
Oh, I'm sorry, did you say specifically that the doctor does this kind of surgery? I didn't really hear.
Yes, he says that he manages, oversees, and participates in all aspects. That includes the surgery that Dr. Vulcano performed, the surgery that he performed, and everything in between. The PT recommendations, the pain management, everything. He does personally absolutely everything that could have possibly been a part of Mr. Vallone's care. And the surgery he did, by the way, was a removal of bone in a different part of the heel, the back of the heel, and a tendon repair. This is a surgeon that does the same thing every single day, which is why when he looked at the imaging that Dr. Vulcano never ordered post-surgery, he said, your Achilles is probably torn. And then he opened him up, and with his own personal observation, based on his experience, his training, and his personal observation, which defendant's expert does not have, because he was not actually the operating surgeon, which our expert is, said, yep, iatrogenic injury. This is caused by the surgery. There is no other cause of it. Nothing else could have caused this. This is what I saw. This is my opinion, clear as day. This is a battle of the experts. It's a garden variety battle of the experts. Justice Kelly said exactly, well, he didn't say that. He's much nicer than that. But he said this can only be resolved by a jury. And I want to note one very important piece of law, that whether a witness is qualified to give expert testimony is entrusted to the sound discretion of the trial court, provident exercise of which will not be disturbed absent serious mistake or error of law. That means that Justice Kelly said even his level of expertise is something that I can determine, and that really the appellate departments should not generally, absent a serious mistake of law, weigh in on, which there's clearly not present here. What a fine distinction that's being offered by appellants as to what his level will be. Basically that he has different letters after his name, not that he's actually the same level of expertise and performs the actual procedures, which he did. I want to address one last thing, though, is that he didn't just throw blanket opinion up in his opinion. He said exactly what Dr. Vulcano did wrong. He said he used the wrong incisional approach. That incorrect incisional approach caused the tear to the Achilles at the time. If your honors have any additional questions, I'm happy to answer them now.
Thank you, counsel.
Thank you.
So, counsel, I have a question. Why isn't the statement by Dr. Del Monte at the 1152 of the record that his extensive experience includes managing, overseeing, and participating in all aspects of the type of care and treatment as that which was rendered to the plaintiff? Why isn't that sufficient to establish, that he has participated in and overseen exactly the kind of care that was given here?
He's participated and overseen this type of injury. He never once has...
That's not what he says. All aspects of the type of care and treatment.
Your Honor, respectfully, this is a highly specialized procedure that very few surgeons do. If asked directly whether he has ever done this procedure, I guarantee he's going to say no.
Is that in the record?
He never said...
Was he ever... Okay.
He never said he did it, and that is the whole basis for the Carey case.
And that will be an excellent question at trial, I would expect.
Respectfully, Your Honor, I don't believe that he has established the requisite foundation in terms of demonstrating that he has the expertise here. And even if you do consider it, he also did not address the issues regarding the plaintiff's progression of symptoms. He had absolutely no complaints with the Achilles for 2.5 months until he was walking on the beach, which is noted in his deposition testimony, the physical therapy records, and in the records of Dr. Volk.
Why isn't that an issue of fact that you'll explore at trial?
Because he didn't acknowledge these facts in the record, which render his opinion incompetent to overcome our prima facie showing of summary judgment.
Thank you, counsel.
Thank you.
People versus Jackson.
Good afternoon, Your Honors. Phoenix Rice Johnson on behalf of Mr. Johnny Jackson. Mr. Jackson was wrongly assessed 15 points under Factor 1 for physical injury when he should have been assessed 10 points for forcible compulsion. Prior to the SORA hearing, the prosecution provided a written submission in which it provided a single rationale for assessing 15 points, and that was based on the statutory language of the offense to which Mr. Jackson pled guilty. Similarly, in the board's recommendation, in its case summary, it provided the same rationale based on the statutory language to which he pled guilty in full
But in the case
satisfaction.
summary, didn't it also say the defendants acted in concert? Is that sufficient notice under the circumstances?
It is not, because the case summary, the only instance in which it said that Mr. Jackson acted in concert was in the facts section, and it said that he acted in concert to abduct the complainant, which is true. He admitted to that. That is part of what he pled guilty to, but it is not sufficient to prove that he acted in concert to, or prove accessory liability for physical injury. The prosecution did not provide that argument in their written submission prior to the SORA hearing, and for that reason, it waived the argument.
Also, in the case summary, did it say anything about the co-defendant hitting and choking the victim?
It did, but it did not indicate that Mr. Jackson was going to be assessed points because of his co-defendant's actions. Accessory liability is a statute that requires two prongs. First, that it shows that Mr. Jackson provided an objective level of assistance, and second, that Mr. Jackson shared his co-defendant's mental state. The prosecution did not provide clear and convincing evidence of either of those prongs. What occurred is Mr. Jackson told his co-defendant that the complainant wished to leave, and after he did so, his co-defendant, without any prompting, walked over and struck the complainant. Mr. Jackson did not provide the level of aid that rides to accessory liability. The quintessential example is when the defendant restrains the complainant so that his co-defendant can sexually assault the complainant. Mr. Jackson did not do anything even remotely similar in this case, and moreover, the record does not indicate that Mr. Jackson shared his co-defendant's mental state. In fact, as he testified to at the SORA hearing, after his co-defendant struck the complainant, he stopped his co-defendant from striking the complainant again, and he asked everyone to leave his apartment. So at best, the evidence is equivocal as to whether or not he shared his co-defendant's mental state.
If we were to agree with you that the 15 points were wrongly assessed, what's the remedy at this point? What should we do?
This court has discretion to correct the number of points that Mr. Jackson is assessed under Factor 1. He should be assessed 10 points for a total factor score under Factor 1 of 10 for a total score of 70, rendering him a Level 1 registrant. He will still be a SORA registrant. He will still have to provide certain information, and anyone who wants to find out about his registration status can call a number.
I think a more appropriate remedy would be to remand.
No, Your Honors, because the court below has already had the opportunity to hear this case, and I'm presenting, you have all of the evidence before you, and this is the appropriate venue in which to correct the total score in this case.
But it's not only about the score. Once you correct the score and the level changes, don't you have to then assess the arguments for upward and downward departures?
Well, the case in that my opponent here cites to with respect to an upward departure is Weber. But in that case, the prosecution below did not have the opportunity to argue for an upward departure, whereas here they did make an argument for upward departure, and the SORA court below found that the prosecution did not provide sufficient evidence to serve as grounds for an upward departure.
Well, that's for an upward departure to level 3, because it's a presumptive level 2. But if we take away those points, he becomes a level 1. Now the court has to assess whether the upward departure is appropriate for level 2. That's a different analysis.
Yes, Your Honor. Well, in this case, you have the complete record before you. The prosecution already had the opportunity to make that argument below, and Mr. Jackson does not pose a meaningful risk to society such that an upward departure would be necessary in this case. Thank you, Your Honors.
Thank you, counsel.
May it please the court. Good afternoon, Your Honors. Christian Rose for the people. This court should
What do you say
affirm
the remedy is, or should be?
the appropriate remedy if this court disagrees with the assessment of 5 extra points under Factor 1 is to remit and remand for the SORA court to decide in the first instance whether an upward departure to level 2 is appropriate. That's also the appropriate remedy, by the way, for if there actually was a lack of notice. But there was no lack of notice because the people were not required in their written submission to notify the defendant that their recommendation aligned with the board's alternative reason for assigning 15 points for physical injury. In the same paragraph that the accessory liability facts occur is the same paragraph in which the subsection, the erroneous subsection of the sex trafficking law is included. So I think that they are in the same section.
So they're supposed to just guess to know what exactly your position is? I mean, that seems, even if it's not a statutory violation, that would seem to me it goes to sort of a constitutional issue with respect to notice and an ability to prepare for the hearing, no?
They're not guessing no, because the case summary includes the factual predicate that the defendant conspired with his co-defendant to inflict, and in their scheme, inflicted physical injury on the victim. So that basis is there, as well as the basis that the people relied on in their written submission that the subdivision of the sex trafficking law that the defendant pleaded guilty to called for those points, which we concede is incorrect. So the defendant did have notice of this, that the people didn't also include it in their written submission is of no moment because the people are not required to notify the defendant when their recommendation aligns with the board, only when it differs from the board.
So when did you raise for the first time the issue of accessory liability?
At the SORA hearing, but that theory was also included in the case summary. In many SORA cases, there is no written submission at all. The people are only required to notify the defendant when their recommendation differs from the board.
But that was not this case, right?
Right, but the people were not required to.
Well, so what does it matter if what you're not required to do? You did it, so the question is whether it's correct or not, right?
Yes, I mean, that's really the issue here because, again, the proper remedy for a lack of notice would be remit and remand, which we argue, even if there were no appropriate points scored under physical injury, the appropriate remedy there would also be remit and remand. I'd like to focus on the upward departure and that the aggravating circumstances here clearly warranted an upward departure to risk level 2, assuming that the defendant was only a presumptive level 1 offender. The egregiousness of the crime was unaccounted for by the REI, as well as the defendant's lengthy criminal history and his lack of genuine remorse that he expressed both at sentencing and at the SORA hearing after the court had already made its finding about acceptance of responsibility under Factor 12.
Just to make clear, that's the argument that you're making to convince us for an upward departure to level 2. But when you were in lower court, you were arguing for a departure to level 3, correct?
That's right. The argument is that the record is full enough for this court to affirm on the alternative ground of an upward departure to risk level 2, which it appears that the SORA court believed was the appropriate risk level when it denied the downward departure to level 1 and denied the upward departure to level 3. I think that the record's clear enough for this court to affirm, but of course the appropriate remedy would be remand for the SORA court to determine whether an upward departure to risk level 2 is appropriate.
Anything else, counsel?
I'd just like to highlight the egregiousness of the offense because the defendant.
But that goes to the upward departure, right?
Right.
I agree. A woman had to jump out of the 5th floor window to save herself.
That's right.
Was severely injured. We read the record, so yeah. So thank you.
If there are no other questions, thank you.
First, I would like to briefly explain that the SORA statute with respect to notice requires not only that the points that are allocated, that he received notice of the total number of points allocated, but also
the underlying basis.
Sorry, what was
the underlying basis?
The underlying basis, precisely. And in the case summary, the clearest indication that the board provides is it says, based on the subsection of the kidnapping charges which he pled in full satisfaction, he will be scored for inflicting physical injury to the victim. That is the explanation that is most clearly asserted in the case summary. But with respect to these upward departure points, first, with respect to the fact of what happened to the complainant on the second day, both the sentencing court and the board made clear that Mr. Jackson was no longer involved in the offense at the time that happened, and for those reasons, he would not be assessed any points or be considered to be involved or have any liability with respect to happened on that second day. So that's a very important aspect to acknowledge when thinking about the egregiousness of the offense. Moreover, Mr. Jackson served 9 years. He did not receive a single disciplinary infraction. He completed sex offender treatment programming, and he excelled in programming. He took on multiple leadership positions. He served in his local Veterans Association. He took on a facilitator and leader role in a program aimed at educating other incarcerated people about HIV and other infectious diseases. He has had a truly exemplary rehabilitation, and he poses a meaningfully reduced risk of any kind of reoffense. He's a much older man now. He's in his mid-60s. And so these arguments for an upward departure don't take into account his extraordinary rehabilitation, or they point out things that are already well accounted for in the RAI. The RAI is uniquely designed to consider the factors of what happened at the offense, and factors 1 through 3 do precisely that. So the egregiousness of the offense is already accounted for in the RAI and should not serve as an independent grounds for the upward departure. For all of those reasons, we ask that your honors consider the facts in this case and reduce Mr. Jackson's points to 10 under factor 1 for a total of 70 points, or independently grant him a downward departure. Thank you, your honors.
Thank you both. Carver versus, next case for argument, IO Experience versus CNA Marketing.
May it please the court, your honors, good afternoon. My name is Jacob Lewin on behalf of the appellant CNA Global. At issue on this appeal is that the order of Judge Crane that was issued in 2020 erred by failing to exercise appropriate discretion to vacate the note of issue that was filed by respondents, given that all of the delays in discovery were actually the result of respondents.
You know, I agree with you, counsel, what you're saying, but your client or the lawyers have to take some responsibility as well, because the court in her order said if there are problems, come back to me. What did you do with respect to that?
Well, at a certain point, Your Honor, we did have a conference with the court that's in the record. That took place on January 6th. That was before the note of issue date. We actually discussed potentially seeking additional time to complete depositions, to complete discovery. And at that point, Respondents' Counsel represented they would waive their right to take our client's deposition, but at no point did we waive our client's right to take deposition. To that end, we actually offered to complete our client's to complete plaintiff's deposition, our deposition, before the note of issue date, but that was rejected.
But that offer was made very late, wasn't it?
Excuse me, Your Honor?
When did you make that offer?
Well, that was at the conference. We still had 11 days to complete depositions.
But it was beyond,
The note of issue date was for January 17th.
but the date for completion of EBT?
That was January 7th. We were
So-
proposing that we would have an opportunity to at least complete it before the note of issue date.
But you'd already missed the date for completion of EBTs at that point.
It was the day before, but no, we had not completed it. We had not, at that, that was January 6th. It was before the January 7th date in the order.
I'm sorry. I'm sorry.
So from July to January, you never suggested another date for the EBT, right?
It's not about July, just to give the timeline. It's
Well,
very
in
critical.
July is when you made the demand for an EBT. I'm sorry, that was the date, the original date for the EBT.
So we filed our
After-
notice. We filed our
Between then
notice.
and January, there was no other time when you said, show up for your EBT on such and such a date, right?
Just to go back to the July date.
Could you answer my question?
Yeah, I can, Your Honor. But the July date, that was before, really the first.
I know that, but my question is, at any time between the date in July when the EBT was originally noticed for and January, did you ever write or call the other side and say, hey, we want your client to show up on this date for the EBT?
We didn't even have documents until December 10th, Your Honor.
So the answer is no, you didn't
No,
ever
we
do
did
that.
not. We
Thank
didn't have document production.
So speaking of the document production on December 10th, you get voluminous documents. What do you do about it? When do you seek the court's intervention? What do you do?
At that point, we were reviewing the documents and we were approaching the date. We had already.
And didn't the judge give you a specific remedy in case there were issues to contact the judge? Was that done?
We did contact towards the beginning of January. We did contact the.
But that's like a month later. You have hard deadlines, the court says no waiver of deadlines, and you wait essentially till January to do something that you should have done in December when you received the documents.
Regardless of that, Your Honor, we still have the opportunity. The depositions were not actually completed. There was no effort, even by Respondents' Counsel, to reach out to us other until January 2nd to schedule our client's deposition. This is a situation where both parties, and I would submit that Respondents were a little more at fault than appellants here, but that depositions were not completed, and there was an opportunity, at least in the first 2 weeks of January, to complete those, and that were summarily rejected by respondents.
But the second week in January was beyond the date that the court had set for the completion of EBTs, right?
After the January 7th, but we submit that we did not waive it because we informed the court that we're still willing to complete it before a note of issue date.
Counsel, the court tells you you're going to waive depositions if you don't do them by January 7th. On December 10th, you get 16,000 pages of documents. Do you reach out to your adversary and say, this is crazy? How can I go through this before the deposition? And then if your adversary didn't respond to you, did you reach out to the court? Judge, we got 16,000 documents. 16,000 pages of documents. There's no way. Did you do any of that, counsel?
No, the record demonstrates that we did not do that, Your Honors.
And Counsel, you're almost out of time. Do you want to address the summary judgment aspect of it?
I want to talk about the post-note of issue opportunity to complete.
Well, you might have to do that in reply at this point. So
That's just to point out that we consider this to be unusual circumstances, given that we were given 46 days to complete all of discovery with all those documents.
Okay, thank you.
Good afternoon, Oleg Rifkin for the respondent.
Counsel, I have a question.
Yes.
In your brief, it seems to me that you didn't oppose or even address appellant's request for review of the denial of its motion for an extension of time to make its motion for summary judgment. Given that you didn't address that in your brief, why shouldn't we view that as an issue that you conceded?
He still has a burden to prove on it.
I understand he has the burden of proof, but assuming he met the burden of proof, when you don't oppose it, can't we view that as a concession?
I don't respectfully know, Your Honor. I don't think it should be viewed as a concession. The court.
But you agree that you didn't address it. You certainly didn't oppose it, and you didn't even address it in your motion.
That is correct. I did not address the issue of the summary judgment. That is correct, Your Honor. And in any case, the points that I want to make, Your Honor, is that after canceling the deposition in July, there was no mention at all of any deposition. There was no notice. There was no discussion of any dates.
You have to send another notice, right? He sent you a notice already.
He sent us a notice, and then he canceled it unilaterally. And after that,
where's the evidence in the record that he canceled it unilaterally?
yes, Your Honor, it's in.
I mean, it
yes.
might be in your affidavit, but in terms of that's not.
Well, it's in the submission. It's on R105. It is my email to counsel on January 2nd, 2020, where I summarized what had transpired between us.
But that wasn't a contemporaneous evidence of that fact, right?
No.
It was your view of many months later of what had happened.
Which he did not.
That's not really, okay.
Well, I mean, I got a phone call, Your Honor, saying no deposition. It's not going forward. It's not going forward.
That's not in the record, is it, counsel?
Well,
is that in the record that you got a phone call saying that? I didn't see it. Perhaps it's there and I missed it.
well, in my affidavit that I submitted in opposition to the motion to vacate the note of issue, I recited that this is what had transpired, and that affidavit is in the record, Your Honor.
R105, correct, counsel?
Yes, R105. That is correct, Your Honor. And he does not dispute that. There's no dispute on his part that he did cancel the July deposition and that there was no notice and no suggestion of any date, no proposal of any date until we got to the very end. And I was the one who served the notice of deposition on December 10th after the judge issued her final order and said, this is it, this is the last one, no extensions. I immediately served a deposition notice. That deposition notice was for January 6th. No response from him, no communication whatsoever from counsel. Finally, on January 2nd, I write him an email saying, please confirm that you are producing your client on January 6th. The response that I get, and this is a fascinating thing, is, well, plaintiff's deposition goes first. He tells me no, plaintiff's deposition goes first. Now, he hasn't...
That is the usual rule when he's noticed.
But he hasn't proposed any date at all, nothing. So I followed the court's order. I issued a notice of deposition. And Your Honor, I should point something else.
Counsel, if you're relying on how much more you followed the court's orders, I think you're on weak ground, because there are many of the court's orders directing you to produce documents at various times which you just completely ignored.
Well, I wouldn't say that I completely ignored. We both produced documents at the same time.
No, he produced documents in October and you didn't. At that point, you simply said, I'm not producing documents without a confidentiality order, which was an issue you didn't bother to raise at the compliance conference a month before.
That is not correct. Respectfully, Your Honor, that is not correct. I had no problem with the confidentiality order.
Right, but you hadn't raised it until October 17th.
I can't recall exactly when I raised it. I cannot recall that exactly.
That's what the record shows, counsel.
Well, in any case.
That was the day you were supposed to produce documents, not to raise confidentiality order for the first time.
I complied with the court's last order, Your Honor. I complied.
Well, what about all the other ones, counsel?
I think we both did not comply with.
That's not what my reading shows, but go ahead.
Well, I think that the conversation that we had with the clerk, this is the point I want to make, the conversation that we had with the clerk.
Again, counsel, is that in the record? If it's not in the record,
Well, he's the one who was saying, I'm just correcting what counsel said. He said he was willing to do the depositions in the next 2 weeks. That is not what he asked for. He asked for a 40-day extension.
Is the contents of the phone conversation you were about to talk about in the record or not?
I'm only rebutting what counsel said.
Answer my question.
No, it is not, Your Honor.
Please don't, again, try to tell us something that is not in the record.
How can I not correct something that counsel said?
You cannot use something which is not in the record. You had an opportunity to put whatever you thought was appropriate in the record. If it's not there, you can't use it now.
That's fine, Your Honor. I understand.
Thank you, Counselor.
I do want to highlight and underscore that there's nowhere in the record did we cancel the deposition in July. And in fact, to the contrary, there's an email which is in the record plainly that Mr. Rivkin, on behalf of his clients, actually identified and said that all discovery was stayed.
But counsel, you didn't go forward in July, and not before January did you suggest another date for that deposition, correct?
We did not suggest another date, but we also didn't have any
The
documents.
6 months went by without your requesting that they show up for a deposition, right?
I would submit that we would require documents before we would actually take an EBT. We had our notice of a deposition that had already been filed and served. That remains and keeps us with priority, and then documents don't show up until December 10th. At no point were we inclined to actually request a deposition when we don't even have documents. I submit that that's not something that we would normally, in the course of normal litigation, do. But regardless, to talk about the point about additional time to complete summary judgment, that I think we have met that burden for good cause, and that is not opposed.
What's the good cause?
As already mentioned before, that we had almost no time to actually complete a full review or even complete any depositions or even post note of issue subpoena, which was served to complete that deposition, and we would like to at least have that opportunity before we complete any motions for summary judgment.
Wouldn't the right thing to have done is when you got the papers, the 16,000 pages on December 10th, to call the court on December 11th and say, we've got a problem being ready for depositions by January 7th, when they just dumped 16,000 pages on us, and if the court wouldn't take your call, to make a motion at that point? Why didn't you do that?
Your Honor, I will fall on that sword, and yes, there would have been opportunity to do that, but this is a case which is rife on both sides of not fully being straightforward and upfront with the production and the resolution of documents. This is a case which was on a very fast track. You know, it's been 3 years since this is an issue, and plaintiffs have not really moved this case at all. We submit there's no prejudice to even continue with having some depositions in order that we can proceed to trial and actually have all the facts before us.
Thank you, counsel. Ward versus the NYPD. The appellant?
If it pleases the court, thank you. Good afternoon, Your Honors. My name is Tabitha Ward, and I'm responding to the denial of the firearm application that I applied for in April of 2020. I applied for the firearm application. I interviewed in 2021, and I received a denial in early 2021 on the basis of, they said that I lacked moral character.
Forget about the moral character for a minute. Let's put that aside, that issue aside. There are certain requirements, other requirements that you have to fulfill. Is it your position that you fulfilled all the requirements?
I did.
Okay.
I fulfilled them all.
How did you fulfill them?
The persons prohibited from from possessing a firearm is that anyone under indictment of a crime. I was not and am not under indictment of a crime. Anyone convicted of a crime, I do not have a criminal record. I was never convicted of a crime.
There are concerns, for example, of what happens if something were to happen to you. How would that firearm be safeguarded?
Yes.
How did you fulfill that requirement?
I requested that it be placed in a casket with me, and they told me, well, we cannot have that placed in a casket with you, but they never gave me the opportunity to come up with another remedy, which would have been, I would will it to the military. I would just simply will it to the military. The other thing is that you have to, anyone who's been mentally adjudicated mentally defective, that has never happened to me. Anyone dishonorably discharged from the military, that has never happened to me. Anyone in the states illegally, United States illegally, that doesn't apply to me. Anyone subject to a court order, restraining order, that does not apply to me. Anyone convicted of a misdemeanor crime or domestic violence, that does not apply to me. I've never been convicted of any of those things. I don't have a criminal record. In December of 2021, I received a letter from a judgment from the Honorable Judge Kelly that stated that my firearm license was denied because I had been convicted and that I had been sentenced to community service for an arrest in 2011, and I told them that this was not true. I had to show proof that this was not true. I had to show proof that they said there was a summary for a parking ticket. I did have a summary for a parking ticket from the Transit Adjudication Bureau. However, this ticket was dismissed, and question number 23 in the firearm application says, been arrested, indicted, or summons for any offense other than parking violations in any jurisdiction. And I was written this ticket, Transit Adjudication ticket, from a parking meter maid, and when I showed that I was still within the transfer time limit there, that the ticket was dismissed and I did not have to pay for it. And I showed them the judge's ruling on that it didn't have to be paid for. And they stated that, just because they had written the ticket for you, that it shows lack of moral character. Also, because you was charged, even though the case was dismissed because the relative admitted that she had provided false statements, because you was charged, it shows lack of moral character. And I was trying to explain to them that, anyone can charge you with anything, but if you're not convicted, then it does not stand. And I don't have a criminal record. I have followed everything else that they required under the May issue. I followed everything that was required to achieve the firearm license. And now that we're under the Bruin ruling, shell issue, I'm still under the compliance of it. And
I'm sorry, anything else? Is that it?
yes, sir.
Okay, thank you. You will get an opportunity to respond too.
May it please the court, Tahira Sadri appearing on behalf of the New York City Police Department License Bureau. The License Division here rationally found that there was good cause for the denial of petitioners' firearm license, a carry license, based on the lack of good character and based on the failure to comply with the investigation and produce a...
I would rather you focus on the latter aspects, the failure to comply as opposed to lack of good character. So what specifically are you saying that the appellant didn't comply with?
The appellant failed to produce a completed safeguard form. The safeguard form is designed to identify a person who can take possession of a firearm and ensure that it is safely handled and safely disposed of in the event that the license holder is either disabled or...
So why not? So her response was, as you heard, and it's in the papers, that she would like it buried with her, or now she says that she'll will it to the military. Why is that not sufficient?
I mean, for one thing, of course, this doesn't accommodate the situation if she is disabled rather than dead. But it's a matter of ensuring the safekeeping of the firearm. And so, in the event that somebody dies, before you get to the point of disposition in a will or of a funeral, you need to have somebody an actual person who is qualified and of good, who is qualified to actually take possession of the firearm and ensure that it is safely taken care of. The idea that it will eventually make it into a casket is not satisfying that requirement of safeguarding, making sure that it is not stolen, that it is not just taken and used in an appropriate manner or left out and unsecured in an inappropriate manner.
Besides the safeguard affidavit, what else did she fail to do?
She also failed to produce affidavits of good character, which are also of good moral character, which are required. She failed to produce the driving abstract from the Department of Motor Vehicles. Those are the issues that I recall that were identified by the license.
And is it your position that there were false statements made?
It is also our position that there were false...
What were the false statements?
The false statement was the fact that she did not, she had not received any summonses or aside from the arrest in Alabama.
What she says is the summons was dismissed. That's not...
Both the application itself and subsequent communications indicate that she needs to identify all summonses or arrests, notwithstanding that they have been dismissed or sealed, or that all of them must be disclosed, and that was made clear to her. And again, it was not a parking summons.
So, counsel, I take it as your position that moral character aside, that these failures are sufficient to provide a rational basis to deny the application.
That is correct. That is correct. Both grounds are adequate grounds for denying the license. If the court has no further questions, I will rest on my brief.
Thank you.
I would like to respond to the summons. The summons was from the Transit Adjudication Bureau. It was written by a parking meter maid, and it was number 23. It says here that any offense other than a parking violations. So it came from there, and this is why I responded. The driving record is that I live in New York City, and I've lived here since 2011, and I've never owned a vehicle here. I have a driver's license, but I've never owned a vehicle, so I could not provide a driver's record here because I've never owned a vehicle. The last time I drove a vehicle was in Washington, D.C., so that's the reason why I did not provide that for her. And the character references, I did give references from my doctors, my medical doctors. So they did write letters. I got 3 letters from my doctors, and I submitted those as character references, and one...
But putting aside the issue of character...
moral character.
Isn't counsel correct that, at least with respect to the safeguarding, you didn't state a person who would
as far as for safeguarding, Your Honor, if I'm dead, even if I appoint somebody to take the firearm in the event of my death, Who's to say that person is going to be there at that time? Who's to say you can get in touch with that person and bring them there? I mean, it'll be, you have to get a hold to my will, read the will, identify the person, find the person, get them come in and let them grab the firearm and do whatever is requested. I mean, you know, people die in different places, and who's to say that? I asked that it be placed in the casket with me, but if they don't, it can go to the military. But then you'll have to get in touch with the military. You have to get them to come down. They'll have to get the firearm. I mean, either way, you still have to go through a process. And if they wanted me to, I would have given them. It would have been the military. It still would have been the military. Even now, I would still say it would be the military. But, you know.
Thank you. Thank you, Ms. Ward.
you.
111 West 57th.
Good afternoon. Gary Mennett. Oh, sorry.
Just a minute, counsel.
Good afternoon. Gary Mennett for the Apollo defendant.
Just a minute, counsel. Let
sorry.
everybody settle down. They're behind you. You can't see. You have 9 minutes.
Thank you. Good afternoon, Your Honor. Gary Mennett for the Apollo defendants appellants. We respectfully submit that the court below erred by not dismissing count 2 of the second amended complaint. That's the sole remaining claim against Apollo for breach of the implied covenant of good faith and fair dealing in a pledge agreement. And we submit that that claim fails for 2 reasons. First, plaintiff's claim against Apollo was dismissed. Plaintiff's claims against Apollo concerning the same transaction were dismissed in an earlier decision on the merits by Justice Sherwood.
But is it fair to say that that was a dismissal on the merits? Wasn't it more of a failure of the pleading itself?
No, Your Honor. The decision by Justice Sherwood it says in multiple places, it is true that it does not say that it is with prejudice. However, it does say in multiple places that it is pursuant to CPLR 3211A1, and Justice Sherwood expressly relied on documentary evidence that he cited as irrefutable, what he called irrefutable evidence, and that is in his decision at pages 7 and 8, pages 1969 and 1970 in the appendix, where he cites the a shortfall contribution letter. At page 8 of his decision, which is in the appendix at 1970, where he talks about the mezzanine loan agreement at issue, and in pages 8 and 9 of his decision, which is in the record at 1970 and 71, where he cites and excerpts the joint venture agreement, and at 1971, where he cites the intercreditor agreement and a joint venture organizational chart. And so he talks, he notes that the decision is pursuant to 3211A1 as well as 3211A7. So it's not just a pleading motion, it's also with respect to the papers that were submitted and cited on documentary evidence. And in his decision, he spends at least a paragraph, I think 2 paragraphs, talking about what evidence can be considered on a 3211A1 motion. And we cited a dozen cases on the point that because it is 3211A1, that all by itself is sufficient
If we
to
were to
be on the
disagree
merits.
with you on that, is there another basis for the appeal?
In addition to the res judicata point, we also argue. Can I make one more point before I move on from res judicata? So I did want to note that with respect to the res judicata point, We cite the Plaza PH 2001 versus Plaza Residential Owner case, which is First Department 2012, and Justice Manzanet was on that panel. And in that case, the court addressed a very similar fact pattern, and said that, noted that before the First Department had ruled on plaintiff's appeal from the dismissal of the first complaint, plaintiff commenced a second action basically on essentially the same claim. So you have virtually the same situation here. What happened here was there was a case filed in 2018 before Justice Sherwood. He dismissed that case in 2019. The plaintiff perfected that appeal, fully briefed that appeal before this court, and before the appeal was scheduled for argument, they withdrew it. And in the stipulation, the written stipulation withdrawing that appeal, it specifically says that the appeal is being withdrawn with prejudice. And that is in the record at 2115, the stipulation signed by me or my colleague, and signed by plaintiff counsel at that time, Stephen Meister, says the appeal is withdrawn with prejudice without cost to any party, and the judgment, which was Justice Sherwood's judgment, shall remain without modification. That is, essentially the same fact pattern that this court looked at in Plaza versus Plaza. Again, Justice Manzanet was on that panel.
Counsel, I'm curious. Are you saying that a withdrawal of an appeal with prejudice means that the underlying order was also a dismissal with prejudice?
No, that's not what I'm saying. But what happened in Plaza versus Plaza is the same exact thing happened as what happened before Justice Sherwood. The order that was submitted said with prejudice, and the order that was entered did not say whether it was with prejudice or not. What I am saying, to answer your question directly, is that when the appeal was withdrawn with prejudice, that meant that they were essentially in a box. They could no longer appeal Justice Sherwood's decision, nor could they collaterally stop it. The only remedy that they had left was to go back to Justice Sherwood and seek to amend that complaint. What I submit they could not do is what they're trying to do here, which is say, we're going to abandon that case before Justice Sherwood, and instead, now we're going to go to Justice Cohen, who has a...
If his underlying order was a dismissal without prejudice, their withdrawal of the appeal with prejudice wouldn't affect the nature of the underlying order, would it?
No, that's correct. But what Rule 5013 says, and what this court's precedents say, is that the issue is whether the dismissal is on the merits. And CPLR 5013 says it's not on the merits unless it specifies otherwise. And that's why, what we submit is that it did specify otherwise, because Justice Sherwood made clear that he was dismissing pursuant to 3211A1, and he was dismissing on the merits because it was not a technical...
About 2 minutes left. If you would proceed on to the argument as to why you believe, in any event, even if we disagree with you, why you think that the implied covenant can't be asserted.
Okay, so on the applied covenant issue, and Justice Gesmer was on the panel in transit funding, we rely on the transit funding case. In the transit funding case, what the court held was that where a party has a right that they can exercise in their sole discretion, the covenant of good faith and fair dealing does not serve to negate that provision. And that's exactly what the plaintiff is attempting to do here. Now, what plaintiff argues is that the prior appeal, in this case, Justice Singh, you were on the panel on that appeal in 2021, they say, well, look at, on that appeal, the court allowed an implied covenant claim to go forward on the same pledge, and that is true. But in that case, the pledge specifically reserved the bad faith claim. And so that is on page 775 of the appendix. On page 775 of the appendix, 774 and 775, the pledge outlines the remedies if there's a default, what you can do under the UCC. Now, under the UCC, you cannot agree to a sole discretion type provision. You're always subject to good faith, and so it says, except for claims, damages, demands that against the lender arising from bad faith, among other things. But here it says exactly the opposite. Here, what the pledge agreement says on page 772, and this is section 5C, it says, in the event the lender assigns the interest in the loan in accordance with the loan agreement, right? You can assign in accordance to the loan agreement, so then you look to the loan agreement. On page 660, which is the loan agreement, it says that you can assign as the lender deems appropriate to one or more persons. That's section 8.9.
So is it your position that this is a sole discretion provision, and it?
That's correct, Your Honor.
And what the plaintiff is attempting to do essentially is negate your contractual right.
That's exactly correct, Your Honor, and that's very well established in this court. Transit funding is.
Thank you, counsel.
Thank you.
Thank you, Your Honor. May it please the court, Haley Proctor for the plaintiffs.
So why don't you start with this last bit?
Yes, okay, with the implied covenant. Absolutely, Your Honor. So there are we have two responses to the points that counsel for Apollo made. The first is that this is not a sole discretion contract. But the second is that even for sole discretion contracts, as this court recognized in Schatz, the implied covenant still exists. It's just that sole discretion carves out a broad field for action. Here, the conduct alleged would exceed even the limits of the broad field of action that would be carved out by sole discretion. But again, this is not a sole discretion contract for a few reasons. The first is section 8.9 of the loan agreement is the provision that governs assignments. It does not use the word sole discretion. The only choice that it gives the lender is as to the amount of its interest that it assigns. Section 8.2, which is the language upon which Apollo relies most heavily, is about approvals and disapprovals. We are not complaining about Apollo's exercise of its approval and disapproval rights. And yet it only uses the language sole discretion, which is distinguishable from the extreme discretion conferring language in all of the cases that Apollo cites, including transit funding. All of those cases conferred things like absolute discretion, the discretion to decide for any reason whatsoever, for no reason at all. All sole discretion confers is the discretion to decide without input from another party.
But doesn't that give Apollo essentially a sole discretion to exercise its rights in the way it deems fit?
It's approval and disapproval rights, which of course is not what we're complaining about here. But it does not give them discretion to exercise bad faith in the way that they exercise those rights. Even if there were case law, which there is not, the decisions that Apollo cites are fact, and this is turning to the conduct alleged, but all of these are fact-bound decisions that the conduct alleged in those contracts lay within the field that the parties agreed to, which, again, absolute discretion for any reason whatsoever does carve out a broad field for action. But it is utterly implausible to think that a borrower would agree that a lender could transfer a loan for the purpose of carrying out a bribery scheme that would take away all of the borrower's property. And this court has previously recognized that the complaint in this case describes an intentional bad faith bribery scheme. And what Apollo is now asking this court to do is to say that contracts using the language sole discretion in some provision anywhere blesses the sort of conduct that this court has acknowledged we have alleged here.
Well, it seems to me that's a broader argument than they're making. What I understood their argument to be is that they have the right to assign the loan and that their discretion as to whether or not to assign the loan is very broad, and therefore that a claim for breach of the covenant of good faith and fair dealing can apply here where they had a good commercial reason for wanting to assign the loan.
Well, Your Honor,
I think you're trying to make it a much broader claim than that, right?
No, Your Honor. So there are a few issues. The first is that the contract doesn't actually give them broad discretion to assign the loan. But secondly, to the extent that it gives them a choice about whether to assign, it's the nature of the implied covenant that they must exercise that discretion in good faith. Thirdly, I don't think any of the cases stand for the proposition.
In other words, if a lender decides it wants this money and assigns the loan, isn't that a commercial purpose, a good commercial purpose? It wants to recoup its monies now.
Right, Your Honor, and that's the third objection I would make to Apollo's argument is that it's asking the court to infer facts contrary to the allegations in the complaint, and we're up here on a motion to dismiss. Justice Cohen properly credited the allegations in the complaint that Apollo did not act for a good commercial purpose, that in fact they acted as part of this impermissible bribery scheme, and that was an act of bad faith. And the final point that I would make on this, Your Honor, is that even if there were a rule under New York law that the implied covenant of good faith and fair dealing is incompatible with discretion conferring language, which again, there is not, it would not be available to Apollo in this case because this is a UCC contract, and the UCC expressly provides that the duty of good faith and fair dealing is not waivable. That's section 1304 and 1302. So for all of those reasons, Justice Cohen properly held that we had stated a claim for breach of the implied covenant of good faith, and I would ask firm. Unless the court has further questions on the appeal, I can turn to the arguments on the cross appeal.
Hold on one sec. I think we're good. Just give me a minute.
Yes, Your Honor.
Oh, actually, your adversary reserved time to respond, so let him respond, and then we'll go to the cross
Understood, yes.
appeal. So,
Thank you, Your Honor. So I wanted to note that the transit funding case was on a motion to dismiss. So the idea that this can't be decided on a motion to dismiss, I think, is not correct. We don't need to wait for summary judgment. With respect to the terms of the loan agreement, Ms. Proctor is correct that Section 8.9b simply says that the lender can assign as it deems appropriate. However, there is a separate section that applies to the entire agreement, which is called lender's discretion. And that is, I referred to this in my opening remarks, but that's at 656 of the appendix, Section 8.2. And it does not merely apply, as Ms. Proctor said, to decisions to approve or disapprove. That's not correct. It says approve or disapprove, or to decide whether arrangements or terms are satisfactory. Obviously, one arrangement that is in the lender's discretion is whether or not to assign part of the loan. It had an unrestricted right to do that. And then it goes on to say that that is in the sole discretion of the lender and shall be final and conclusive. So this is not a limited language. This is broad, sweeping language. It applies.
So it's similar to language exercising its absolute discretion.
It's in my view, it's exactly the same effect. Sole discretion, final and conclusive.
Thank you.
Thank you.
Okay, now we go to the cross appeal.
Thank you, Your Honor. I'd like to begin by discussing the claim for tortious interference, which Justice Cohen dismissed, at least in part, on the basis of the lender's economic interest defense. And there are three independent reasons that the economic interest defense did not supply a basis for dismissal. The first, and generally, it must be recognized that like any defense, like any privilege, this is not a defense that sanctions pursuing any financial interest for any reason whatsoever. And so the first and the simplest reason that on the pleadings the court should reject the economic interest defense is that, as this court has recognized, the complaint in this case alleges that the lenders acted by means of a bribe. That is an illegal means, and the economic interest defense is overcome by allegations of illegal means. The second reason is that the economic interest defense is not even available to the lenders in this case. The economic interest defense applies when the party is acting to defend a pre-existing interest in the breaching party.
But if their action in assigning the junior mezzanine loan could have been a commercially reasonable action, even if, as you claim, it had to do ultimately with participation in a bribe, wouldn't that defense still stand?
No, Your Honor, and this court has been quite clear in the White Plains case, in the Wells Fargo case, that it's not just commercially reasonable actions being protected by the economic interest defense. The party must have an interest in that it's looking to protect in the breaching party. That's why, for example, a business can't go and solicit competitors' contract customers, right? That's a commercially reasonable action, but it still would subject them to liability for tortious interference with contract. Here, the breaching party was an equity holder, and the lenders are all debt holders. They're ahead of the equity holders in the waterfall. They have no interest in the equity holder. And not only that, but the lenders didn't act to protect the equity holder in any way. They, in fact, wiped out the equity. So the breaching party here is 111 West 57th Sponsor, LLC. After the strict foreclosure was carried out, that entity had absolutely no interest in the property any longer. So this case is on all fours then with the Wells Fargo case, where the owners of an entity induced that entity to breach a contract with another party. In doing so, they hurt the entity in which they had an interest, even though they were acting through economic motivations, and the court recognized that that did not describe, that did not invoke the economic interest defense to begin with. And then the final reason is that even if the pleadings here would support the lenders invoking the economic interest defense, we have, as I mentioned, adequately alleged illegal means, but we have also adequately alleged malice. And that is, especially with respect to the Apollo lenders, there is no clear economic commercial reason for the Apollo lenders to have acted as they did. On the facts alleged in the complaint, the lenders were simply acting to help rid the sponsors of a pesky investor. That is malice under the case law, and therefore we have pleaded enough facts to survive a motion to dismiss on the basis. And that's the final point that I would make here, Your Honors, is that we are up here on a motion to dismiss. And while it is theoretically possible to dismiss a complaint on the basis of an affirmative defense, it is telling that the Spruce defendants here feel the need to make factual allegations that are contrary to the allegations in the complaint. And there's one that I would like to highlight. Repeatedly throughout the briefs, the Spruce defendants make statements that make it sound like the sponsors, Stern and Maloney, put additional money back into the project after the strict foreclosure, and that is why they came back into the ownership.
So what was the sponsor's breach here?
Yes. Okay, so then there's the underlying breach. There are three independent underlying breaches here that would support a claim for tortious interference. The first is that the plaintiff had bargained for the right to veto certain decisions being made on behalf of the borrower. And the sponsors breached that provision, that it's called the major decision provision, by handing over the borrower's property, transferring the borrower's assets in exchange for a discharge.
It's not really that they handed it over, it's that they failed to object to the strict foreclosure.
Yes, so the statutory default
The
here.
strict foreclosure wasn't the decision of sponsor, right?
Well, the decision to propose a strict foreclosure was not sponsor's decision, but that proposal gave the borrower a choice: continue in default or get out of the default by surrendering your property in exchange for a discharge of indebtedness. So the choice between those two alternatives belonged to the borrower, and the sponsors made it without our input, despite a contractual provision requiring them to get our input on transfer. You are correct, Your Honor, that due to the statutory default that turns silence into consent, the sponsors were able to make that decision without taking any affirmative steps. But that doesn't change the fact that they made the choice, and it was a choice that was reserved to the plaintiff.
So you refer to the major decisions provisions, but under the joint venture agreement, didn't the sponsor have the right to say, no, we don't agree with the plaintiff's request to make an objection?
So, Your Honor.
So would that be a breach then, under those circumstances, if the contractual agreements allowed them to do what they did?
only consenting to the strict foreclosure proposal resulted in an action that was covered by the major decision provision. So in the event that the two parties disagreed on the proper course of action to take, the sponsors were contractually obligated to maintain the status quo, and the way that they would do that is by objecting to the strict foreclosure. There are also two other provisions at issue here. There's Section 8.5, which imposes a contractual duty not to engage in intentional misconduct. Now, that intentional misconduct is a fiduciary concept, but this court held on the previous appeal that 8.5 waives fiduciary duties and replaces them with contractual ones. So the duty not to engage in intentional misconduct is a contractual duty. It was clearly violated here, as this court has previously recognized. And then the third basis is the breach of the implied covenant of good faith and fair dealing. This is the flip side of the breach of the implied covenant claim that this court previously recognized in the previous appeal. These are the insiders who were suborned.
Wouldn't you have to sort of claim against the sponsor for that breach? And have you, in that case, alleged that the sponsor breached an implied covenant?
Yes, Your Honor. We do have a pending claim for that breach.
You want to address, your time's running out, do you want to address the unjust enrichment?
Yes, absolutely. So very quickly, the court held that the existence of the joint venture agreement foreclosed an unjust enrichment claim, but that is not the case because the claim covers conduct that was not covered by the joint venture agreement. We are alleging that the Apollo defendants received proceeds outside of the waterfall laid out in the joint venture agreement after the foreclosure had happened, after the company created by the joint venture agreement no longer had an interest in the project. We also adequately allege that it would be against equity and good conscience to allow them to retain it. The complaint is replete with allegations that these are ill-gotten gains, and even if Atlantic is entirely innocent here, it would be against equity and good conscience to allow them to retain these ill-gotten gains that rightly belong to plaintiff here.
Thank you.
Thank you, Your Honor.
Counsel?
Good afternoon, Your Honors. May it please the court, Dan Milstein for the Spruce defendant respondents. It's clear Justice Cohen was correct in applying the economic justification defense, and the appellant's limited reading of it isn't supported by any case law or the facts. A secured lender has an interest, not really in a business, and it's not like an equity interest. They don't have an equity interest in the borrower. They have an interest in their collateral. Their security interest is what gives them the justification.
You know, which I understand, obviously, what the claim is, but is that something that we should be deciding at this stage? Isn't that better on a motion for summary judgment as to that claim?
No, Your Honor, because there is no dispute that all of the lenders here were secured lenders. They all had loan agreements, and the allegations are you didn't act appropriately in exercising
Well, because you were part
statutory-
of this alleged fraud to essentially wipe out plaintiff's equity in the project. I mean, that's the claim.
Well, Judge Cohen was correct in saying that the complaint doesn't allege fraud, it doesn't allege malice, and it doesn't allege crimes. It uses the word bribery and other terms like sham foreclosure. It uses those terms.
Excuse me, isn't that a crime?
Bribery can be a crime, certainly. Using the word bribery to describe conduct doesn't make the conduct that you describe a crime. What is alleged here is not a bribe by any definition, either the Black's Law Dictionary or New York criminal law. A bribe requires offering a quid pro quo to get someone to breach a duty of fealty. If you breach your duty to your employer or to someone else you owe a fiduciary duty to, I will give you something, and I will not give it to you if you don't breach. What is alleged here? Stern and Maloney were principals. They owned the business. They weren't in an employment situation. We've already been over the fact that the fiduciary duties were waived in the LLC agreement. They went into this knowing that, when I say they, I mean the partners in the borrower, went into it knowing that Stern and Maloney were construction managers. They were guarantors. Plaintiff was not, was neither of those. They were divergent interests. So Stern and Maloney had no duty to sacrifice their own interests for someone else. And there is no allegation that any of the lenders said to Stern and Maloney, if you let the strict foreclosure go forward, we'll let you be a construction manager, continue to be a construction manager and earn your fees. And we'll let you back into the project later. You can reinvest when we raise capital, which they did, $90 million. But if you don't, if you make us go to auction sale, if you object and we go to auction and we buy it in an auction, which was likely, probably a 99% probability given the circumstances here, we're going to fire you and your money will be no good when we later need money. That makes no sense for anybody to have done that. And that's why the allegations, and those are the allegations, we're not disputing the allegations. This motion isn't about they are untrue. This motion is about assuming they are true, that is not criminal bribery. They can use any label they want. Justice Cohn was very correct to say, you don't even attempt to allege the elements of criminal bribery, and it's just not there. And this court previously, you know, what the allegation of the plaintiff is that, well, it's already been decided that this is bribery. No, it hasn't been decided. This court addressed a very narrow issue previously, and it said, it was asked whether a damages waiver barred a claim for breach of the implied covenant of good faith and fair dealing as a matter of law at the pleading stage. And it said, look, these allegations that there was a financial inducement, put the finger on the scale to have Stern and Maloney tip one way or the other, that's sufficient allegations of bad faith that might overcome a damages waiver. Similar to where a landlord under a lease says, I'm not going to give you consent to do construction or sublease, even though I'm required to give you my consent and not unreasonably withhold it, unless you increase the rent. Courts have said, you might have a damages limitation or waiver in your lease, but that type of bad faith conduct to exact something you're not entitled to will get you over it. That's the narrow issue this court was addressing previously. Nowhere has any court said that exercising a UCC remedy is malicious, there was any fraud involved, much less criminal conduct. So we think the judge correctly applied the economic justification defense. And the arguments that it's not available because the lenders didn't have an interest in the borrower's business and didn't benefit the borrower as a going concern is absurd. Secured lenders have an interest in the collateral pledged to them. Whenever they exercise their rights and either take that collateral or sell it to a third party, the borrower is not happy about it. It doesn't help their borrower, but it doesn't mean that their economic interest is any less legitimate. It's just a different interest. And the Wells Fargo case is nowhere near on point on this issue. Wells Fargo case didn't say any of these limitations to the economic justification defense apply. All it said was the person who was accused of tortiously interfering didn't act in furtherance of their interest when they sold it. And the sale was, in fact, its breach. It's not what Spruce is accused of doing. Spruce is accused of acquiring the interest, then putting $80 million in to cure the loan imbalance and making sure the project was completed. It didn't divest itself of an interest, it acquired the interest and then acted to the benefit of everybody involved. There are other...
Plaintiff, correct?
Right, everyone?
Well, Your Honor, when you're a borrower and you default on your loan, there are bad things that happen. It doesn't make it illegal, it doesn't make it
But it
fraudulent.
doesn't mean it benefited everyone.
Well, they got off the hook on a $25 million loan. And they might poo-poo it and say, well, there wasn't a recourse under these circumstances. It's far from settled that they wouldn't have been personal recourse under these circumstances. There are other reasons to affirm the judge's decision below, even if you come out differently on the economic justification defense. Chiefly, it's a fanciful idea that, well, it's fanciful. It is theoretically possible to base a tortious interference claim on an underlying breach of the implied covenant, but as Justice Cohn observed, there are some serious hurdles there in pleading, because you have to plead not only knowledge of the contract, but awareness of the specific term breached and an intent to bring about that breach, none of which can be...
Was there a breach, an underlying breach by the sponsor here?
No, not at all.
Because if there was, then maybe it's a better argument. If there's none...
No, there's none, because, I mean, Justice Cohn assumed, he said, I don't have to address whether there is a breach of the underlying implied covenant, because the economic justification defense applies no matter what. I'm saying there isn't even a breach of the implied covenant here, and certainly, even if there was, there wouldn't be an intent to bring about its breach, because we wouldn't know that Stern and Maloney had an implied duty to sacrifice their own personal interest to that of their partner, who's saying, test the market, go to auction, no matter what happens to you. You know, that's not a viable theory of tort, that we knew that anybody could have known that, given the terms of the contract. But the idea that Stern and Maloney breached an implied covenant is not apparent at all on the face of the contract, of the complaint. It doesn't allege any of the necessary elements. It just says, well, if there wasn't a breach of the two express terms that I've identified, surely it breached an implied covenant. What implied covenant? A covenant that if we are faced with a strict foreclosure proposal and we have a difference of opinion and I want you to go to market and you don't because you're afraid that you might be liable on your guarantee or you have other reasons, that you're going to capitulate to my wishes and object anyway? That's the implied obligation that exists. I don't see it under this contract. I don't see allegations that would support that claim in this complaint.
Thank you, counsel.
Gary Mennett again for the Apollo defendants, now on the cross appeal. Justice Cohn was correct to dismiss the tortious interference claim as against Apollo. All that Apollo is alleged to have done here is the Spruce assignment. The Spruce assignment was at par, so Apollo had a loan. They sold a $25 million piece of that loan, assigned loan agreement, a split-off loan agreement, and a split-off pledge to Spruce. There's no allegation that Apollo transferred anything to anyone else other than for value. There's no allegation that we got anything but for value, $25 million loan for $25 million, dollar for dollar. There's no basis for throwing around the kind of inflammatory language that plaintiff throws around. The tortious interference claim fails because the assignment of that loan was simply Apollo acting to protect its own contractual and economic interests. Obviously, Apollo had this bigger loan to the extent they could sell $25 million of it for $25 million to Spruce. Apollo then reduced its own risk in the transaction. That's classic economic justification. They didn't do anything other than that. They're not alleged to have done anything other than that. They say we amended the intercreditor agreement to allow for that. Okay, but that's, there's nothing improper about that. There's no allegation that we did anything improper. I did want to just touch very briefly on the Wells Fargo case. In Wells Fargo, the plaintiff relies heavily on this today and in their papers. But there, the owners of the borrower transferred their shares to inexperienced new owners in violation of a transfer restriction in a loan document. So the lender had said to the borrower, you can't transfer this loan to someone without telling us who's going to take over the business. And they transferred it to someone who had no experience in the business, and the business failed. Well, that's not the allegation here. There's no allegation here that we were transferring the loan to someone who didn't know, how to be a mezz lender. It's completely off point, has nothing to do, in my view, with this case. Unless the panel has any questions, that's all I have. As I said in my remarks on our appeal, I won't go through it again, but the loan agreement specifically says that we had this broad right to assign all or any part of the loan, and that's all we did. And that was in our sole discretion.
Thank you, counsel.
Thank you.
May it please the court. Brittany Lazaro on behalf of defendants, respondents on the cross appeal, Atlantic 57 LLC, Madison 57 LLC, 57 Madison LLC, excuse me, and Arthur Becker individually. For over 5 years, this case has been going on. Throughout the case, Atlantic defendants were actually subpoenaed as non-parties. During that time, we produced documents. While plaintiff had, despite having the benefit of years of discovery, including from these Atlantic defendants themselves, plaintiff is still unable to articulate a claim. In the operative complaint here, the Atlantic defendants are barely mentioned. Plaintiff routinely employs improper verbiage by grouping together the defendants, which is in contravention of CPLR 3013 and 3014. In fact, by plaintiff's own allegations, they concede and acknowledge that the rights and obligations with respect to the company are governed by the JVA. That's in paragraph 44 of the complaint. The JVA is attached to the complaint itself, 173 to 278 in the record. There's no claim that the Atlantic parties, or Atlantic itself, breached the agreement whatsoever. Since the unjust enrichment claim is premised solely upon matters extensively covered by the JVA, the dismissal should be affirmed. In addition, even assuming the JVA did not exist, plaintiff failed to allege any direct dealings or actual substantive relationship between it, Atlantic 57, Mr. Becker, respectively, that would cause any kind of reliance or inducement. There's no benefit conferred either. There is one paragraph in the complaint, 130, which is alleged on information and belief, where plaintiff includes conclusory allegations, speculates as to what the Atlantic defendants did here, engage in some backroom deal when that's not what happened. While plaintiff contends in its brief that Becker was purportedly attempting to sell Atlantic's carried over equity to an investor in China, this is false. This is the only allegation that supports any conduct. It is with respect to only one of the Atlantic defendants. And as we noted in footnote 4 of our brief on page 18, it's also noted in the complaint itself, non-party Grunda Investments advanced Atlantic $26 million in net capital to the company that came from overseas. As plaintiff noted on page, as the Atlantic defendants noted on page 19 of their brief, on plaintiff's brief, page 58, plaintiff noted that had the junior mezzanine lender proceeded with the public foreclosure auction, then plaintiff, along with Atlantic, would have received the share of the surplus value paid to the borrower. That's precisely correct. Atlantic would have, in fact, received its surplus as well. It did not. We've been monitoring this case for years. We have not joined the plaintiff's side of this case because we doubt the claims exist at all.
So in a nutshell, what you're saying is you were a co-venture and there was no real benefit that you obtained. Is that correct?
There was no benefit, correct.
Okay, thank you.
Thank you, Your Honor.
You'd asked for 2 minutes. I'll give you an extra minute.
Okay, yes, sir.
It's complicated. Not legally, factually.
All right, just a few points, Your Honors. I'd like to first address Apollo's role in this because we hear that all they did was exercise their discretion to transfer the loan. But in fact, Apollo played a critical role in recruiting Spruce into the deal by sending financial models, making promises that Spruce would be able to get control of a cash flow worth hundreds of millions of dollars, which was something that Spruce could only have done if it could get a hold of the equity. And then Apollo ensured that that happened.
So are you claiming that you alleged illegal activity by them?
Yes, Your Honor.
Counsel disputes that.
Yes, Your Honor. But in the complaint, we do allege that Apollo sent these financial models to Spruce that said, hey, if you get control of the equity here, it's going to be worth hundreds of millions of dollars for you. When Spruce agreed to purchase the loan, Apollo transferred it to Spruce, and then Apollo exercised.
They transferred it at par.
They transferred it at par for
How can that be a bad thing?
it's a bad thing because it was in order to enable Spruce to then
No,
foreclose.
for their purposes, they got what they were looking for. They got $25 million, right? The fact that Spruce then stood in the position to benefit, well, they wouldn't do it if they didn't have a benefit.
Yes, Your Honor, but they came to Spruce and were able to present that benefit to Spruce because they knew that Spruce was going to be able to take control of the equity, which they could only have known if they had this
the sponsor
deal.
was not going to object to the strict foreclosure.
Precisely, Your Honor. And Apollo's cooperation was essential to providing the financial incentives that Spruce and Apollo offered to the sponsors to consent to the strict foreclosure. So Apollo was aware of what was going on, was facilitating what was going on. And Apollo got another benefit here, which was they got rid of a pesky investor. And that is why we believe that we have adequately alleged malice to overcome any sort of economic interest defense. And I will note that although Apollo continually invokes its discretion, this court recognized in the previous appeal that Section 8 of the pledge agreement still makes the exercise of discretion subject to claims for willful misconduct. And again, we have alleged that in spades with respect to Apollo. Quickly, we do allege the elements of bribe. The sponsors were acting on behalf of the borrower. They were agents for the borrower. They received a quid pro quo. It's very notable that that Spruce is having to allege that they would have hired Stern and Maloney on even if there had been an auction sale. That's an allegation from outside of the complaint. So the idea that we haven't adequately alleged a quid pro quo on the facts that we have put into the complaint is simply not supportable. And then finally, on Wells Fargo, I just want to point out that the court announced a rule that you cannot claim the economic interest defense when you act to the detriment of the breaching party. The principals in that case were still looking to protect an economic interest, their investment, by getting it out of the deal, but they still couldn't invoke the economic interest defense because they hurt the breaching party.
I just have one last question. With
Yes, Your
respect
Honor.
to Atlantic, what was the benefit?
What was the benefit for Atlantic? Oh, so yes, it's simply not true. That the amended complaint alleges that Atlantic received a nearly $20 million payment, or an entity affiliated with Atlantic was able to raise nearly $20 million at the time of the Madison transaction. So that certainly supports an inference that Atlantic did receive a benefit for the equity that was carried over.
Thank you, folks. Thank you, Your Honor. Thank you very much. We'll see you probably in a year or so again. That's what she was saying. I don't know. Okay, folks, the case I skipped over, Gupta versus YM Pro.
May it please the court. Mark Rousseau for the defendant appellant YM Pro Corp. It is our position that the Judge Sattler of the New York Supreme Court, New York County, erred in denying the motion for summary judgment on the third cause of action for negligent supervision. And the law is clear on the requirement for negligent supervision that the employer must have known or should have known of the propensity of the employee to commit the tortious act. And that is simply not the case.
How is that established
Sorry?
generally? Couldn't a fact finder look at the alleged aggressiveness of the perpetrator, how he conducted himself on the job site, to make a determination? Or you're saying that as a matter of law, that it's insufficient here?
Well, we believe that it is in line with the way Zuckerman talks about mere conclusions and expressions of hope to raise a triable issue of fact. It's simply, there is no connection between the tortious act, which is a physical assault, and the behavior that is discussed by Mr. Gupta and the affidavit of the foreman for YM
Brown is argumentative. He appears to attempt to pick some kinds of fights, those kinds of things. No physical violence before the incident. So it's your position, in effect, that there needed to be some physical violence before for there to be notice?
Or it's some kind of precursor to physical violence. The fact that he's argumentative and that he uses foul language, which is in essence...
That he has an aggressive attitude?
Well, one tremendous vagary in the use of the term aggressive attitude, because that would include every single high school athlete, and that would make them, in essence, unemployable, because it would open up liability to their employers for any action that results eventually into a physical assault. And then that is the case with regard to the behavior that's described within the construction industry itself. It's our position that if this were to be the standard established, then probably 90% of those involved in the construction industry would render themselves unemployable because they're a liability risk because of being argumentative and using foul language. And actually, it would probably imply...
But it's more than that. Didn't the plaintiff, as I recall, also testified that other YM employees complained about Brown's hostility towards them and the like?
Well, again, these terms are tremendous vagaries where none of them actually testified. It was only things that were heard by Mr. Gupta. And so,
well, absolutely, it's hearsay, but this is in opposition to a motion for summary judgment. Hearsay is permissible under those circumstances.
Well, again, the terms are extremely vague, and therefore that there has to be some kind of connection between the conduct that's described and the tortious act itself in order to rise to the level of a triable issue of fact. Because of that knowledge, the knowledge is not just the demeanor of the individual employee, it's the actual tortious act. And so demeanor may be deplorable, yet that doesn't mean that this individual had a propensity to strike somebody with rebar. That's a huge leap from being argumentative and looking out for arguments on a construction site.
Okay, anything else?
If there aren't any questions,
thank you.
Good afternoon, Your Honors. May it please the Court, Rosa Feeney of Smiley & Smiley, and we represent Chris Gupta in this matter. I think, as Your Honor has hit the point, the issue here is there a question of fact for a jury to determine? And I think based upon the evidence before the court...
What facts are there in this record that will put the employer on notice of the propensity of this defendant?
The foreman himself acknowledged that he had aggressive behavior at the site, and that...
Is that enough? Aggressive behavior, that equals propensity to attack someone?
Well, that together with the testimony of the plaintiff indicating all of these different things, where he says the people in the job site were saying he was crazy. Everybody knew he was crazy. They say he was always looking to get into an argument or a fight with someone. I think that, he was hostile.
But he didn't get into a fight
before
the incident. He did not get into a fight.
No,
so the
but
question is did it has to rise to that kind of level of aggressive and inappropriate behavior for there to be notice, or something less is sufficient?
I think that's for a jury to determine that in that particular environment, right, he's saying it's a construction site, so I guess they can just curse and act however they want.
It's not a free-for-all just because it's a construction site, but the question is, in terms of the term crazy and the term aggressive and wanted to fight, without providing any factual basis, isn't that just conclusory language?
No, I think it's what they observed. And it's their observation of this person, and their observation is what a jury is going to hear.
Saying that someone is acting crazy is a conclusion based on something that you observed, right?
Excuse me?
Saying that someone is acting crazy is a conclusion based, one would suppose, on something that was observed.
Yes, but they did observe, and there was testimony that he was always trying to get into an argument with somebody, that he was argumentative, and that he was aggressive. So there is that testimony, and while it's contrary to what the defendant has said, we're not setting the standard here. All we're doing is deciding whether there's a question of fact for a jury.
Are there cases that say what acts constitute propensity for violence?
Your Honor, there's no specific cases that I found. I know that the cases that we were citing in here, that they had cited in particular, there was actually evidence that the people had no aggressive history.
I mean, I mean, I think you're right. I mean, the case law doesn't say specifically what it is. So the question is the alleged persistent display of aggressive behavior, is that something then a jury should consider whether or not that there was a propensity?
Yes, I think it should. I mean, not to mention the fact that it also came out that apparently he had a knife on him on the job site. I mean, these are things that should all be considered by the jury. Is this something that perhaps the employer should know? And
Isn't a knife a common tool used on a construction site?
Could be, but he took out the knife apparently and threatened the workers when they held him back. And the testimony of the actual owner of YM was basically that he wasn't on the site. He hadn't been on the site for 3 weeks. That it was basically on autopilot. That it was being handled by the foreman, and the foreman himself said this guy always had an aggressive attitude. So I think that there's sufficient evidence to bring this issue to the jury based upon the testimony of what they observed. Should someone at the job site had said this guy's got to go.
Thank you, counsel.
With regard to the knife, there was no indication whatsoever in the record that there was any prior indication that this individual either carried a knife or used it to threaten anybody. In fact, Mr. Gupta denied that he observed Mr. Brown threaten anybody with physical violence at any time. And some of the other admissions that Mr. Gupta makes are, I think, eye-opening. He never observed any physical altercation. He never reported any concerns to YM Pro. He was the site safety manager, and he never reported or wrote up Mr. Brown for any behavior that he supposedly observed. He denied ever seeing Mr. Brown working or behaving unsafely, and if he had, he said that he wouldn't have that person on his job site. He was in charge. He could have excluded anybody at any time from the job site, not only Royal, who was the GC, and his employer, not only their employees, but anybody on the job site, because they were the GC and he was the safety supervisor. He denied ever observing Mr. Brown threaten anybody with violence. All of these.
So let me ask you this: Why the case law? I think your adversary is correct. It doesn't really specify what acts are necessary to establish propensity. Based on what you're saying, why isn't this really fodder for cross-examination before a jury, so the jury could determine whether or not there's sufficient evidence on notice?
Well, for that to open up to any kind anything, even self-serving and vague expressions would open up to raise a tribal issue or fact, and then summary judgment would be somewhat of a useless tool in order to limit issues to be tried by the court. And also, I think that there has to be some kind of connection between the tortious act, again, which the cases are consistent. It's not just the demeanor, but the tortious act that has to be the driving force of.
So in other words, there has to have been a prior punch. I mean, now we're making it like the dog cases.
Well, I mean, the courts have obviously found that the one-bite rule is no longer viable, but there has to be some kind of precursor of something more than just argumentative tones. And there really isn't anything here.
Thank you.
Thank you very much.
People versus Davis.
No, that's
No,
submitted.
that's
Oh, I'm sorry, it's submitted.
We're on
Apologize.
Hilton.
Hilton versus WTC.
Good afternoon, Your Honors, and may it please the Court. My name is Georgia Carr-Connect, and I represent ThyssenKrupp Elevator Corporation. The issue before the Court, or the central issue before the Court, is whether or not an entity identified by ThyssenKrupp as an indispensable and necessary party to the action should have been joined in the...
What makes this party indispensable and necessary?
Your Honor, Condé Nast is a tenant within the World Trade Center building. Attached to our motion is a copy of the lease that Condé Nast had with the security company that plaintiff was employed by. The face of the document clearly compels the security company to perform services related to the elevator, which would include reporting any dangerous condition or safety concerns with regard to the operation of the elevator. I think on that basis alone that there's an inherent duty on the part of Condé Nast to have reported any prior misoperation or dangerous condition with respect to the elevator.
Perfectly reasonable argument. Why not just bring Condé Nast as a third party into the case?
Well, Your Honor, ThyssenKrupp is not a party to the contract. And under an Espinel, to answer that specific question, Your Honor, because this was not discussed in the lower case, but under an Espinel analysis, we're not a beneficiary to the contractual obligations within the Condé Nast contract with the security company. Therefore, that could potentially be grounds for dismissal of a third-party action, whereas there is a direct duty that would be in the plaintiff's interest if they were added as a direct defendant that wouldn't preclude recovery against Condé Nast. So in order for there to be a complete recovery amongst the parties, it is our position that they should have been joined as a direct party. Thank you.
Thank you.
May it please the court, Robert O'Hare for the respondent. We submit, Your Honors, that Justice Hagler did not abuse his discretion in denying the application here, mainly because there is just no legal authority to support the application that was made by the defendant below to add this party as a necessary party. The facts just don't support it.
But you heard the argument. There's a contract, and maybe there's a breach of contract, and maybe that's the basis for liability.
That might be true, Your Honor, but that would essentially eviscerate the whole doctrine of joint and several liability. The plaintiff has the right to bring the action against any wrongdoer, any individual tortfeasor. If there's multiple tortfeasors, there's procedures in the CPLR to bring that party before the court, either in the main action or subsequently.
Can there be complete relief here between the parties you've sued without joinder of Condé Nast?
There could be the complete relief that would be that could be obtained here would be by virtue of either the third party action that you suggested, which we disagree with counsel, that the allegations that would be set forth or that would establish the third party action would somehow not withstand the motion to dismiss. One, two, the other way to go about getting complete relief, if you will, would be a subsequent proceeding for contribution or indemnification, which is provided by the law. I will point out that this is, in a sense, a little bit black letter law with respect to not having to bring in a joint tortfeasor in every single personal injury case. And the joint commentaries are directly on point on this. Professor Alexander addressed it specifically. And it says, it might seem that a joint and several tortfeasor is the sort of person whose joinder would be necessary in order to achieve complete relief for the existing parties. Nevertheless, long-standing precedent provides otherwise, and Professor Alexander cites the Second Department case of Siskin versus Levy. And then he adds, joint and several tortfeasors are merely permissive parties under the CPLR 1002, and he cites to the Court of Appeals case, Hecht versus City of New York. And he notes, despite the inefficiency of multiple litigation involving the same tort, the standard of CPR 1001A is not met because a plaintiff's judgment against one of several tortfeasors cannot be undone by other suits. The defendant does not face double liability, and the other tortfeasors will not be inequitably affected. If the defendant wishes to obtain reimbursement from other tortfeasors, he has the remedy of impleader or a separate suit for contribution or indemnity. And he cites also to the practice commentaries under CPLR 1007 and 1401 to 1404. And I would just add, Your Honors, that this is, the standard here is abuse of discretion. Justice Hagler looked at the facts. There's no case law, no precedent cited to support the application below. And we'd submit that this decision here was not an abuse of discretion.
Thank you, Counselor.
Your Honors, it has always been the philosophy and the rule of the court for full and fair adjudication of all issues that come before the court without the necessity of multiplicity of suits, that in an issue or in an action that could be decided in one action. We were at the time at this motion.
Is that a factor in deciding this kind of motion?
Well, Your Honor, at the stage of litigation that we were at when the motion was made, no depositions had been held. We were still very early on where full discovery could have taken place with respect to what the contractual obligations within the Universal and Condé Nast contract actually means, and particularly with respect to my client, if they did not have notice of a dangerous condition or some malfunction with the elevator, it is a defense to liability on their part. However, the contractual obligations come from something that was written by Condé Nast, not something that ThyssenKrupp was a part of.
So I just go back to my question. You can bring them in your own way. You can sue them separately later if that's what you believe. I don't see how you force the plaintiff to bring in a party it doesn't want to bring in because it doesn't believe there's any negligence on the part of the tenant.
Your Honor, the CPLR 1001 simply states that the court is allowed, or the parties are allowed to bring in any other party that is identified to be necessary and indispensable. It doesn't say that we're forcing plaintiff. It's really the court's discretion to bring in a party if it does see that there is a duty, as argued in the lower court, that the central issue here is a duty and a breach of a duty. We've identified that duty that arose in a contract that Condé Nast wrote that required Universal to provide security services that included monitoring of the elevators and the right to submit those complaints.
Thank you all. People versus Bacon.
May it please the court, Anjal Henderson, Columbia Law School extern with the Center for Appellate Litigation, here on behalf of Appellate Xavier Bacon. Good afternoon. I'd first like to address the for-cause challenge, and if time allows, move on to the confrontation clause challenge. The lower court erred in denying the for-cause dismissal of Veneerman Mr. Wadaker following his explicit expression of bias towards those accused of crimes against women. Due to this error, defense counsel at trial was forced to use a preemptory challenge and soon exhausted this allotment.
Was it necessarily a bias against crime against women, or was it a bias, to the extent there was a bias, against charges that involve sex abuse or rape?
Well, no. So Mr. Wadaker did not only mention his college roommate or college friend who was a rape survivor. He explicitly said that he had a natural bias in favor of women and that he was sensitive towards women's issues. He did not limit his statements only to sex crimes. He expressed a clear bias towards those who acted in violence against women. And in this case, my client was accused of violently attacking a woman in a subway station, and the lower court failed to strike him after he did not make an unequivocal and clear promise to remain impartial. The court is required to strike a juror who expresses a relevant bias and does not make an unequivocal promise to remain impartial. And if the court does not strike, forcing the defense to use a peremptory strike, a new trial is required if the defense ultimately exhausts its preemptory challenges, and that is what took place here. Due to this error, we believe that Mr. Bacon is entitled to a new trial. If I may move on to the confrontation clause issues. Mr. Bacon's confrontation clause rights were violated by the introduction of hearsay testimony from the complaining witnesses through the testimony of Officers DeLone and Brudovic.
Wasn't that non-testimonial in nature, though? I mean, the officers are in the middle of investigation, there's chaos, there's the person upstairs. Wouldn't that fall within that category?
Absolutely not. So we are not contesting the statements made in the subway station immediately once the officers were responding to the 911 call made by the complaining witnesses. The issue is 15 minutes later, the statements that are made to the police officers that they soon make in court, where they're discussing what happened, what took place. This is testimonial. This is not them responding to an ongoing emergency. The emergency.
So your position essentially is the emergency is over and therefore it's something different. It's not investigative.
Absolutely.
Or is that something different in excited utterance?
I'm sorry, could you repeat that?
That's something different than excited utterance. So do they qualify as excited utterances?
No, so even in the record, it shows, and Mr. DeLone and Mr. Brudovic testified to this, that the complainants were not excited, that they were falling asleep, that they were dozing off throughout the time that they were being interviewed by them, and they were receiving medical care. There was no ongoing emergency, that there was no excitement taking place whatsoever. It was simply, and they were there in an investigative capacity. There was no longer any emergency, and they were not trying to minimize any threat that could come to the complaining witnesses at that time.
So what's the case law on the issue in terms of what the dividing line is in terms of when it goes from, when the investigation is over? You're saying once the emergency is over, then that's the end?
Typically, once the emergency is over, that is the end of the excited utterances, especially when the complainants are in the midst of being receiving medical care. I apologize.
You just said that once the emergency is over, then that ends the excited utterance. Is that what you said?
Typically, from my understanding, yes. And here, it's clear in the record, as I said earlier, that there was no excitement, that there was no emergency. They were falling asleep. They were dozing off.
I'm not sure that the excitement that's required for excited utterances is dependent upon whether the emergency is still ongoing.
I'm sorry, could you repeat that?
I'm not entirely convinced that the excitement that's required for the excited utterance is dependent on whether the emergency is still ongoing.
It ends it's no longer non-testimonial.
Well, that's two separate things, right? Whether something is non-testimonial, whether something qualifies as an excited utterance.
Yes, they are two different things, but however, in this case, excited utterances typically apply to when there is an ongoing emergency and when there is the excitement of the actual event. There was no excitement of the actual event here when they were being interviewed by the police officers. It was 15 to 20 minutes after the event had taken place. They were outside of the subway station, which is where the event had taken place, and the alleged threat was already far down the subway tracks, as testified by the police officers during the trial. Here, they were receiving medical care, they were in safe hands, and the police officers were solely there in an investigative capacity and getting statements for a subsequent trial. And if there are no other questions, then I also would add that this is preserved. Counsel clearly objected. If there are no other questions.
May it please the court, my name is Patricia Curran and I represent the people on this appeal. The court properly exercises discretion in denying the defense cause challenge as to the panelist here. As Your Honor stated a few minutes ago, this particular panelist never said that he was biased against all women in crimes. He specifically hitched what he said to sexual assault. For example, when he first spoke, he said that his close friend had been a rape victim in college and he was just naturally biased toward crimes towards women, the only thing I would say that might hamper my ability. The following day, when the prosecutor explored this more with him, he again hitched it to the sexual assault of his close friend, saying, I shared yesterday that I have a very close friend who experienced a rape in college and I am sensitive to women's issues. I don't feel like everyone's a rapist, so that when the trial court said to him, I assume it's fair to say that because there are no allegations of sexual assault here, that you could sit on this case, the panelist agreed.
Well, it was a little equivocal, I think.
I'm sorry, Your Honor?
A little equivocal, not a great answer, and no follow-up. by the judge? Can you be fair? You know, those basic questions, right?
You mean the unequivocal assurance?
Yeah, it
aspect
wasn't,
of this?
there was some, I wasn't, I thought more could have been asked or elicited at that time.
Well-
In any event, why don't you address the confrontation clause? That's
Go to the
really a
confrontation
stronger
clause.
argument.
All right, if there are no other questions about the cause challenge, first of all,
How do you respond to your adversary's argument that, particularly the statements that were made 15 minutes later when the excitement had dissipated, don't fall under any exception?
there's no particular time element here.
Well, that's true, but she wasn't basing her argument on time. She was basing it on the facts that they were sleeping, they were being rendered aid. At this point, the quote unquote questioning turned from dealing with emergency to investigation.
Well, that isn't true. They weren't sleeping. First of all, when the officers first arrived, Azillo's physical condition was he was breathing heavily and was pacing back and forth. Then they went down and spoke to, I'm sorry, that's when they first came up from the subway station. When they first arrived, he was yelling and screaming, and then the victim herself, the wife, was bleeding, she was spitting blood, she was upset, hysterical, scared,
Right. I don't think your
shaking,
adversary was challenging that part per se. I want you to address her argument, what happened later on.
You mean in terms of the officers and their investigation, that aspect
Right,
of her argument?
in terms of the admission of those statements. Just because it started off as an excited utterance doesn't mean that every statement that's made qualifies as an excited utterance, correct?
Well, I think there are two things here. I think, first of all of these statements qualified on an evidentiary basis as excited utterances because they met the various standards. And by the way, they never argued below that any of these were not excited utterances. In addition, they never argued below that this was hearsay or a violation of the Confrontation Clause. So if they had, we would have been able to bring out even more information.
But didn't they move to dismiss when it was clear that the complainants weren't going to be called?
When he moved to dismiss, all he said was that he would have liked to have had the witness here to cross-examine her so that the jury, because the jury would get an incomplete idea of the of the case. He never actually said anything uttering the words hearsay or confrontation clause or excited utterance. He never said that. So that, I believe part of my adversary's argument is that she's saying the emergency was over and therefore these are Crawford statements. But A, the emergency wasn't over. They were duty bound to investigate and to talk to these people, to get them aid and to apprehend the person people who had done this in order to A, make sure no one else was injured and to make sure that they brought this person to justice and that he didn't hurt them again. The emergency wasn't over here, and there are lots of cases that talk about, from this state, that talk about how these kinds of statements are not testimonial at all. If the court has other questions about any of the other parts of the brief, I'd be glad to answer them, or about the Confrontation Clause. Seeing none. Thank you very much.
Thank you, Your Honors. First, to the for-cause challenge. Although Mr. Waterker first says that his biases in favor of women were initiated when his college friend was sexually assaulted by an individual, he does not, for one, the court does not go further to ask whether his biases are limited to sex crimes over the defense counsel's request for the court to go further into this. He continues on, besides just saying that his friend was a rape survivor, he continues on broadening his biases, saying that he's in favor of women, that he's sensitive towards women's issues, and this is a case where a woman is brutally assaulted in a subway station by a man. I think this is clear that Mr. Waterker likely had a bias, or more than likely had a bias, and the court did not explore further, and also did not.
But didn't he say that he wanted to hear the evidence first? But he did say yes, seemingly that he could be fair and impartial.
Seemingly, this is not clear and unequivocal. He doesn't say yes,
Counsel,
absolutely.
I think the exchange was the court said, Mr. Wood, sir, isn't it fair to say that there are no sex crime allegations in this case or anything likely to present themselves during the trial, that this is a perfectly appropriate trial for you to sit on? And the juror said, I would hope to hear evidence, but yes.
He says, I would hope to hear the evidence, but yes. At the end of the day, this is not a clear and unequivocal answer, and also the court does not ask the appropriate question. He does not ask Mr. Wadaker whether he can remain impartial in this case, in a case involving a woman who was violently assaulted. They ask if he believes this is appropriate, which this is the question that the court should be asking, and the court should be determining themselves, not the juror that's sitting. If also, I know my time is beeping. If I also may add, even if this was an excited utterance, this does not trump or dissolve Mr. Bacon's right to confront his accusers. In this case, all of the evidence all of the complainant's testimonies were given through the officers, and to the point that this was not preserved. I think it's splitting hairs to say that the defense counsel below had to explicitly state that this was a confrontation clause issue or this was a hearsay issue. Defense counsel below stated that the complaining witnesses did not testify, did not subject themselves to cross-examination, and that the jury was given an incomplete picture, and that this is why the case should be dismissed. That clearly, and I think everyone who understands the law and every lawyer in that room would know that this was a confrontation clause issue, that this was a hearsay issue. If there are no other questions, I rest.
Thank you. You are a student at Columbia?
I just graduated.
Graduate. Well, congratulations, and you did a great job. Thank you.
Thank you very much. Have a wonderful day.
Oversight Management.
May it please the court, my name is Scott Goldberg. I'm the attorney for the Appellant Oversight Management. Appellant recognizes the general rule that releases and settlements are enforced. But here, there are two valid exceptions to that general rule that would require that this valuation tax commission settlement release should not affect a request to correct a clerical error. The first reason is a disparate treatment. We demonstrate definitively that in 5 Mercer Street, a property in Manhattan, and 22 other cases, the New York City Department of Finance adjusted as a clerical error issues for tax years where there had already been a tax commission settlement in those years. That's exactly what we're requesting in this case. 5 Mercer Street actually involved Real Property Tax Law Section 1805, which is this case. And they went back in time.
So speaking of this case.
Yes.
Right? You entered a settlement agreement which says you agree not to commence any proceedings to review the assessment. How can you even bring this case before us?
Okay. Because a clerical error correction
is still a case. It's still a proceeding. I understand. Your position, I understand. But I'm asking you where the settlement agreement says you cannot bring a proceeding, you are bringing a proceeding that violates the settlement agreement.
Okay. Well, disparate treatment. A taxpayer has a right to look how an administrative agency behaves and guide its conduct accordingly.
What happens when the taxpayer enters into a settlement agreement? We throw the settlement agreement out because now the settlement agreement is less advantageous to the taxpayer?
It's not that. It's as to this clerical error issue. I understand where you're coming from, Your Honor.
You could have brought that at the administrative level, but once you bring a court proceeding, that's what's clearly barred by the settlement agreement.
But here's the problem with the position that respondents are arguing. They're saying that this will eviscerate the tax commission settlement process. In fact, it'll open up a floodgate of litigation. In fact, if you think about it, just the opposite is going to happen. When one brings a tax commission claim, it has to be brought in a 45-day window from January 15th, when the roll comes out, until like approximately March 1st for tax class 2, 3, and 4 properties, March 15th for tax class 1 properties. And then that affects the subsequent year. How is a taxpayer, how is an attorney for a taxpayer supposed to settle that tax commission settlement if it means they can never go back in time under New York City Administrative Code 11-206, which allows the Commissioner of Finance to correct clerical errors, or in 2016, the City of New York Department of Finance enacted the clerical error rule to correct these errors.
So you negotiate a settlement agreement that gives you those rights.
But you can't. It's a boilerplate. That would be great. No, but you can't, Your Honor, with all due respect. It's a pre-printed form.
I understand. I understand. But still, it's a pre-printed form. You're an attorney. You can ask for something different.
Your Honor, with all due respect, read the form. It says no. If you make one change to that form, it's not accepted. What you're suggesting is not what the practice is. It's not what the law is.
Counsel, the other 22 cases that you claim show disparate treatment, weren't those all resolved at the administrative level, not at the judicial level?
They were. That was the conduct of the Department of Finance. No one, even in this case, the denial that was issued, the denial was not that there was a tax commission settlement. That was introduced by the law department.
But what the settlement agreement does is to preclude judicial review. So that didn't apply to preclude the other 22 cases, but here you're seeking judicial review.
But I have no other place to go. Yeah, you have the right to submit a clerical error request, and you have no alternative but to bring an Article 78 proceeding if there's denial. In this case, the Department of Finance didn't raise the tax commission settlement. The Court of Appeals says if it's not invoked by the administrative agency, it cannot be invoked at the time of a judicial proceeding. So it shouldn't even be before this court, the tax commission settlement. I cited to that matter of Sherbin. It is the settled rule that judicial review and administrative determination is limited to the grounds invoked by the agency. It wasn't invoked. It shouldn't even be considered here today. If this is the law
But it wasn't an issue before the agency, because what the settlement does is to preclude judicial review, not agency review.
The submission that was made to the administrative agency in this case was that real property tax law 1805 wasn't applied to the property. That's what was submitted. The denial was, or the decision was, they adjusted the then current year, fiscal 2022. Fiscal 2016 to fiscal 2021 is what was contained in the request to correct the clerical error. They didn't grant any of that. When the litigation was brought, counsel agreed to correct this error, as they've done in many of these cases, except for these 2 years. And there was no way to carve this out. If this court grants this relief, and I think the law department is blinded, because they don't realize if they do this, then that means no attorney who represents a taxpayer before the tax commission can ever settle a case again without releasing 6 years of historical clerical errors. If a $10,000 in extra interest was charged, they're foreclosed.
So why not do your due diligence? It seemed to me then you would do due diligence to make sure that when you make that kind of settlement, that there are not monies out there that your client might be entitled to.
I understand what you're saying, but there's a public. Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Kira Wallish, and I represent the respondents in this matter. Your Honors, there's one issue here, and that's about settlement agreements and the importance that they're enforced.
Can you address the disparate treatment argument that your adversary makes?
Yes, Your Honor. Your Honor, in the respondent's brief, respondents mentioned multiple cases where this argument is used by respondent municipality that a tax commission settlement bars future requests for clerical error. There's been multiple decisions by courts rendered on this issue, and in every case where a decision was rendered, the courts have held that that's true, that they upheld the settlement agreement and that the settlement agreement bars future clerical error requests. So it's the respondent's position that there is no disparate treatment in this case. We've made this argument in multiple scenarios, in multiple cases, and the courts have held in favor of respondent in all of those cases.
Is there an issue, I guess a preservation issue, so to speak, with respect to the issue of the settlement agreements not being raised at the administrative level?
Your Honor, it's the respondent's position that the appellant waived its rights. It contracted away its rights to ever bring this suit, so that it couldn't be brought per the settlement agreement. It couldn't be brought at the administrative level, nor could it be brought.
But certainly at the administrative level, you didn't raise the settlement agreements weren't raised, correct?
The actual administrative determination is silent. It doesn't in terms of.
So can you now raise the issue? And if so, why?
Your Honors, we believe we can raise this issue now because the real issue is that petitioner was barred by the settlement agreements from ever bringing a clerical error
court
request.
proceeding.
Your Honors, actually, both an administrative proceeding, which is what a clerical error request is, and the court proceeding. Because proceeding.
But it's clearly you waived your right to say that they couldn't bring an administrative proceeding, and so I assume what you're saying to us is that they can't bring a court proceeding.
Well, Your Honor, yes, we are saying they cannot bring a court proceeding. That is correct. Your Honor, if I can, just briefly, public policy favors the enforcement of settlement agreements. The Tax Commission.
But what about counsel's argument that if you prevail, then no one's ever going to sign a settlement agreement again?
Your Honor, a couple points to that. There are multiple ways that are incentives to settle. First of all, if there is primarily a valuation claim, the petitioner may still choose to settle at the Tax Commission. Moreover, there is a form, the TC 106, which allows petitioners to bring a classification claim at the Tax Commission level. Also, petitioner could decide not to bring a claim or not to take a settlement at the Tax Commission level and bring an Article 7 lawsuit. So petitioner has multiple ways to address all types of assessment challenges. So, Your Honors, as I mentioned, it's public policy. It's to enforce settlement agreements. The Tax Commission resolves tens of thousands of cases a year, saving countless judicial and municipal resources, and also providing finality. Like, that is the purpose of a settlement agreement, is to provide finality to all parties. Justice Perry, who wrote the decision, noted this public policy, how enforcement of settlement agreements are strongly favored, and Justice Perry found, after reviewing the settlement agreements, that petitioner waived its right to seek further review of the tax assessments in years governed by the settlement agreements, and respondents asked that the court uphold the decision of Justice Perry. Thank you.
Thank you.
Public policy. Public policy is for the Department of Finance to strive and do its best to maintain an accurate assessment and tax roll. By enforcing this release of a valuation issue in a tax commission to preclude someone from going back 6 years under New York City Administrative Code 11206, Commissioner of Finance may correct clerical errors. The 2016 enactment by Department of Finance of a clerical error rule that lists all types of issues that they will correct. One of them, 53-02B11, an assessment that increases in violation of a statutory limitation. This case, 5 Mercer Street's case, and other cases that are outside the record, which were not disputed. Disparate treatment was not disputed in the record, okay, will be a disaster. These 10,000 cases that get settled before the Tax Commission can no longer be settled. How can you settle a case for a coming year? By March 1st, you file with the Tax Commission. Before October 25th, when the Article 7 petition is due, that's when those settlements happen for that coming year. Now you're going to give up 2,000 days, 6 years of historical periods. What if an extra $10,000 of interest was charged that the attorney had no idea about? The Department of Finance can use that. They're using this tool as this release, a valuation settlement release, to prevent the correction of a clerical error, to prevent public policy's mandate of having an accurate assessment roll. The law department has lost sight of what they're doing. They want to win this case so badly that they're raising an issue here that the Department of Finance, their own client, didn't raise. Their client did raise the Tax Commission settlement. You know why they didn't raise it? Because their usual course of conduct is not to raise it. That's why they adjusted those 22 cases. That's why they adjusted 5 Mercer Street. Some attorney at the Department of Finance decided, okay, this is a good case to raise this issue in. It's not right. They want to raise it going forward? Let them raise it going forward. Let them change their rules. But those rules are not in effect. And what's the purpose? Why is disparate treatment so important? Why is it deemed to be arbitrary and capricious? Because that's the way the public, taxpayers, can know what rules they have to follow and what course of conduct they have to engage in. This case goes well beyond this particular property. I hope the court sees that. Thank you very much.
Thank you both. People versus Negron.
Good afternoon, may it please the court. Legal Aid Society by Jane White for Mr. Albert Negron. The 2 to 4 year sentence in this case is simply too long. Mr. Negron pled guilty to a charge that took his prior domestic violence cases into account and was exposed to a sentencing range that took his prior record into account. He accepted responsibility and was still sentenced to the maximum. He did not even try to test the evidence in this case by taking the case to hearing. He pled guilty in an upfront court part. The minimum sentence that we're asking for, 1.5 to 3, would account for his record. Mr. Negron suffers from substance abuse disorder, and he is likely...
Didn't he face other additional charges in this case? And it wasn't, so it was all sort of combined and done in one, right? How about that?
Right, he did face the charge of attempted burglary.
There are 3 additional charges, according to my notes.
That's right, the other charges were misdemeanors, and...
So that was taken into account?
That was taken into account, but the people made an offer that I believe, they thought was the right offer and an ethical offer based on all the information, on all of the evidence that they had. So he does have a record, but a criminal history, even a long one, does not preclude this court from making a determination that his sentence was excessive. As his record shows, his more recent convictions are tied into his substance abuse. And just using some of the factors that this court has considered in the Mitchell case, a 2019 case, the last violent felony that Mr. Negron was convicted of was in 1994, 30 years ago. The most recent felony conviction that he has is from 2010, 13 years ago, for a nonviolent drug charge. The last arrest he'd had before this case was from 3 years prior, in 2017. As this court knows, Mr. Negron is someone who's struggled a great deal throughout his life.
Also, isn't this argument foreclosed by the waiver of appeal?
No, Your Honor, it's not. As pertains to the waiver of appeal, to start, the prosecutor has failed to respond to our arguments about the waiver being invalid. So that is not a bar to considering his excessive sentence claim.
What would be the maximum he'd be facing here?
The maximum is 2 to 4 on what he pled to.
No, you mean on the top count?
Yeah.
I believe 5.
I'm sorry, say that again?
5. But in any event, he did not validly waive his right to appeal here because he pled guilty before the court discussed the waiver of the right to appeal with him. He signed the purported waiver of the right to appeal form before the court spoke to him. And the court's discussion of the waiver of the right to appeal versus the jury trial rights forfeited by plea was confusing and prone to misinterpretation by the way the court grouped together the jury trial rights with the right to appeal. The court actually said, for example, if you took this case to trial and were convicted by a jury, you could appeal any decision by another judge or I, but by pleading guilty and signing this waiver, you're giving up those rights.
Thank you. Who's going to ask you? You can ask.
Good afternoon, and may it please the court. Peter
Agree with
Rienzi.
counsel that the maximum charge he faced was 5 years?
No, Your Honor. On the attempted burglary charge, the minimum would be 5 years because it was a violent felony.
And the maximum?
And the maximum would be 7 years, and both would carry 5 years post-release supervision as well. Peter Rienzi on behalf of the people. Your Honors, defendant's negotiated sentence was fair and appropriate and should not be reduced. This was a favorable disposition to defendant. As has been discussed, defendant was allowed to plead guilty to a reduced charge.
Are you conceding defendant's argument with regards to the waiver of right to appeal?
We're not conceding that, Your Honor. Our brief did move directly to the merits of the case. We are comfortable with the court addressing the merits, obviously. We feel like those arguments are not persuasive and should be rejected. We do feel like the waiver, based on the plea colloquy and the written waiver of appeal, this court could uphold that waiver.
Did he receive the waiver prior to the court's explanation?
He did receive the waiver prior. The record appears that he did receive the waiver prior to the court's explanation, but the defense counsel, when he first mentioned pleading guilty, the waiver of appeal was always part of the disposition. It was discussed from the first moment defense counsel said, we have a disposition to the judge. The counsel mentioned the waiver of appeal, and it was also mentioned several times throughout the colloquy. Just sticking to the waiver of appeal for a moment, as we all can read the record, it did say, defendant said he understood it. He said he had no further questions. Both the written waiver and the judge's colloquy discussed that the appellate rights were separate from the trial rights and that certain appellate causes would survive the waiver. Again, though, as to the merits, The fact that defendant received a higher than minimum sentence on this reduced charge was completely appropriate. This was a domestic violence assault followed by the defendant kicking in the victim's door until the lock broke. Defendant has an extensive criminal history, as is detailed in our brief, including violent felony convictions for attempted murder, for robberies, as well as other domestic violence cases, several parole violations. And as noted in both briefs, both sides' briefs, defendant is currently incarcerated on a pending unrelated matter that was committed when he was under parole supervision in this case.
This was also a negotiated disposition, correct?
That's correct, Your Honor. And none of that does not obviously, and we do not claim it does, bar this court from reducing the sentence. However, none of defendant's arguments, all of which were known to the sentencing court as part of that pre-sentence report, none of those arguments merit this court's intervention to reduce the sentence. The sentence should not be disturbed by this court. If Your Honors have no further questions, we will rest on our brief as well. Thank you.
I would just say that just because defense counsel had said we discussed the waiver of the right to appeal, that's no substitute for the court having that discussion with Mr. Negron. And some of the cases, the more serious cases on Mr. Negron's record that the people discussed, those cases are all from the 90s when he was a teenager. And regarding the pending unrelated matter, of course, that occurred subsequent to this case and shouldn't be a consideration.
So let's go back to this. You get essentially an intermediate sentence, right?
I'm sorry?
You get your client gets an intermediate sentence. 5 to 7 is the high, 1.5 to 3 is the low. He's at 2 and 4. It's a domestic violence incident, couple incidents, and also he was facing 3 additional charges. How, under those circumstances, can you say that there's something wrong with this sentence?
I think the attempted burglary charge was a charge that was not even charged in the criminal, it was not charged in the complaint, it was not one of the arrest charges. The people's proof on that charge was not very strong, and I think that they did not do any favors to Mr. Negron by offering him the aggravated family offense charge and the maximum sentence on that charge. I think they knew what they could prove in this case, and so that's why they made that offer. The other charges were misdemeanors. The other charges he was charged with were misdemeanors. So I think we're asking us to reduce his sentence to 1.5 to 3, just given everything that is in the brief. Thank you.
Thank you. Thank you all. Yacarino versus Koenig. Last but not least, you guys get the award.
I've got to hand it to you. It's right on time. May it please the court, Jeff Sheetzold for the appellant. The lower court's ruling in this matter was based upon a clearly erroneous recitation of the underlying facts, and those facts were ultimately dispositive. The rationale for the decision was that mere wetness on a walking surface due to rain does not constitute an actionable condition. A position we agree with. That's just not what happened in this case. The underlying order makes a demonstrably false claim that it is undisputed that the plaintiff fell on exterior steps that were wet from mist. This is most certainly disputed. The plaintiff's testimony, which is unrebutted, was that he did not slip on stairs that were wet from mist, but rather on a pooled water condition that had leaked through a hole in the foundation of the concrete steps. If you look at page 300 of the record, there's a picture of the condition. It's actually very interesting. It's discolored brown because the water is going through the rebar in the steps, and the rust is making the brown stain that you see in the picture. The plaintiff's specific testimony was that the third step from the top had a crack or hole where the groundwater would leak from the foundation and pool on the step. This condition of a large amount of pooled water was separate and different from any dampness on the rest of the steps due to the misty conditions that night. So that's the first fact that they got wrong below. Secondly, the lower court substituted its own words for the defendant's testimony in changing the description materially of the paint that was used on the ground surface. The lower court erroneously cited the defendant's testimony as having used non-slip exterior paint, but the defendant never said that. The defendant only said she used non-slip paint. And by unilaterally bolstering the defendant's testimony, the lower court answered a question it should have been asking, which is, was this paint sufficient for the exterior surface? This is an issue of fact that the court eliminated by creating the testimony out of thin air, essentially. Putting aside the utterly incredible and contradicted testimony of the 82-year-old defendant that she went out and painted an enormous patio in the middle of summer with only a roller in less than a day, the court puts a bow on it for her by saying also the paint was proper for the undertaking. It's especially impactful given that the defendant spoliated the evidence before my expert could get there to take a look at it. But somehow the lower court faults plaintiff's expert for being unable to opine on the condition of paint that no longer existed by the time that he got there.
Did you raise new theories of liability here, sir?
Pardon me?
Did you raise new theories of liability here?
It's not a new theory. I mean, the theory is always negligence, right? The theory is that
Well, the theory is what's the negligence? I mean,
that the homeowner maintained the steps in an unreasonably unsafe condition, right? I think that the best that can be argued in that regard is that a slightly different yet substantially similar theory under the negligence umbrella is being put forth. And point 3 of our brief addresses the standard that this court has employed on multiple occasions of seeking the most liberal construction of the pleadings in these circumstances, giving the plaintiff every possible reasonable inference, and even on an unpled cause of action, denying summary judgment where facts are sufficient to support that cause of action. So I think when you take away the facts that were created by the underlying court, what you get is a defendant that failed to even make out its prima facie case. And in the interest of brevity, I'll skip over the overwhelming body of case law from this court that says when you make a summary judgment motion on a premises case, you have to say when the area was last inspected or cleaned prior to the accident. And if the court would like me to go through them, I will. But suffice to say, there is precisely zero evidence in this case as to when the area was last inspected or cleaned. The defendant couldn't say when she last was on the steps. She said, generally, I walk around.
But your claim really is, that really goes to transitory conditions, I would suggest. Your claim really is that it's a defective condition.
Well, it's a recurrent defective condition.
Recurrent condition meaning because of the pooling of water.
Right. So leaking groundwater onto a step that if you were to walk over it and do an inspection, you'd probably notice. And that doesn't even take into account the fact that the plaintiff had complained to her multiple times. The plaintiff had asked for traction strips to be placed, and she had said, yes, I'll address it with my handyman. They were never placed. And then we've got this pooling water condition.
Thank you, Counselor. You're trying to keep us on time, going overtime.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. George Epstein of Mead, Hecht, Conklin, and Gallagher, LLP, for respondents. Your Honors, the trial court correctly dismissed this matter and...
Counsel, do you agree that there's nothing in the record supporting your claim that the steps were painted with exterior non-slip paint?
So, Judge, I don't know that the word exterior was specifically...
Well, that's the word I'm asking about. Do you
yes,
agree that that's not in the record anywhere?
So I agree that the specific word exterior is not in the record other than in the judge's decision, but the defendant did testify that she used non-slip paint that was a finished product, and the plaintiff testified that he didn't have any information as to what paint was used. The defendant also testified that she maintained some of the paint that was used to paint the steps, and that could have been observed by the expert.
And do you also agree with counsel that there's no evidence of when your client cleaned or inspected the steps?
Absolutely not. My client testified that she checked the premises weekly while she was there.
But she didn't specify a specific date that she'd been there, right?
Not a specific date, but it was a regular occurrence while she was there. Your Honors, the primary issue here is that the entire theory of liability is completely new, created in response to the summary judgment motion. The claimed defect that was listed in the bill of particulars and that the action was pursued on was that there was improper paint that was used, and it was established that the paint was proper, or at least that there was no evidence.
Counsel, but doesn't the complaint allege defective steps, trapper obstruction? There was testimony that the steps were irregular. There was testimony that there was standing water observed on the steps. That's not new stuff. So isn't the claim here really that the steps were defective?
He mentions it in the complaint, in the bill of particular. He testifies to it, and it's in his affidavit. The third step was cracked.
So I would just say that in the bill of particulars, it's very clear that the focus is on the improper paint.
That may be. But the issue is whether or not you're on notice of what their theories are. They may choose to emphasize one theory at one time, and then in response to your papers, they may choose to emphasize another theory. But that's trial strategy. So what is the new theory of liability?
Judge, I mean, I would say that all the theories are new because during the testimony, when she was testifying, she also testified that she did not experience any defect that night, on the night of the incident, when the incident actually occurred. On that day, she testified.
That was after she gave the testimony that they were very irregular. They were not very well uniformed. Counsel didn't accept that description and then asked specifically, was there a defect? And she said no, but she described the defect.
Perhaps she described it, but she didn't describe that as being what caused the incident. It was my understanding. And so
I'll give you another 30 seconds, counsel.
I'm sorry, but so in the bill of particulars, there's just two statements about what caused the accident. It says, in response to your demand seeking the alleged defective condition which caused the claim occurrence, plaintiff is claiming a dangerous condition as a subject to improper paint on the exterior patio, causing plaintiff to slip and fall. And then paragraph 3, where it says, what's the location of the accident? The location of the accident is cited as on the improper paint on the exterior patio. So that is what the focus of the whole case was. So even though the plaintiff may have been testifying that, the stairs were irregular, she didn't testify that contributed to the incident.
Counsel, isn't there a triable issue of fact? Your client says, I painted the steps with non-slip paint. His client says, I asked her to put traction on the steps because they were slippery. Isn't that in itself an issue and a question for the jury?
Well, I don't think so, Judge, because again, when the steps are wet, they're permitted to be slippery, and wetness on the walking surface is not a
pooling is.
He
But
testified.
Go ahead.
But he had stated before that he had slipped on these steps before and that he had approached her and said, these steps are slippery, can you put some traction on it? Why should we believe your client and not hear his client out?
I would just say that the claim that the steps were slippery is conclusory, and there's no evidence that the paint that was used on the steps was defective.
Okay.
I mean, Your Honors, I know my time's expired. I thank you for
Absolutely. Absolutely. Counsel?
Just quickly to answer Your Honor's questions. 40 times between the summons and complaint and the bill of particulars, we say wet defective steps. The defendant's specific testimony when she was asked, and this is page 226 of the record, can you tell me the last time you traversed these stairs prior to September 13th, 2018? Answer, no. So that's, unless there's any more questions, that's all I have for the court. Thank you.
Thank you, counsel. Thank you very much.
expect that.